Provisional application, my lord, against
Provisional application of
PWDB Act, my lord.
under what act?
My lord, PWDB Act, my lord.
No, question is Justice Sharma's determination you are mentioning.
Yes, my lord.
So this bench does not have determination. Only with NI Act, the determination is assigned.
That is hearing matter, Lordship. Hearing 2020, Lordship. Second
So, okay, next month. Yes. Yes.
My lord, it is up to the end of November, my lord.
Anyway, it will appear as to be mentioned.
Well, may I be permitted to mention one claim case, my lord, for inclusion in the list under the heading to be mentioned.
Yes.
Lordship, may I mention for inclusion in a Lordship list motor accident hearing matter?
Hearing matter, yes.
One, two, three.
My lord, item number 1, 2, and 3, my lord. These are analogous case, my lord, arising out of the same accident, my lord. Paper book already filed and sub, my lord. Matter is ready for hearing, my lord. Kindly fix it up, my lord, in the month of January.
No, matter will be heard in the month of January. Prior to that, there will be a Lok Adalat. I'm sending it there. If it is not settled, I will take it up in the month of January.
Okay, my
Yes,
lord.
record an order. Learned advocates for the parties are present. It is submitted by the learned advocates that these matters are ready for hearing. Thus, these matters should appear under the heading hearing. Stop. As these claim cases may be settled through the Lok Adalat, these matters are referred to the National Lok Adalat to be held in the month of December. Fix 6/1/2026 for report of the Lok Adalat.
Much obliged, my lord.
I'm grateful, ma'am.
We gave 1, 2, and 3.
No, four.
My lord, 4 I appear for the appellant, my lord.
4 year for the appellant, yes.
Lord,
What is this CAN 1 for?
my lord, CAN 1 is an application for condonation of delay.
Yes.
Lord, there has been some delay, in fact,
Yes.
quite some delay, my lord.
Give me the records. You are for the respondent.
Respondent number 13 to 16, my lord.
13 to 16. All the respondents have been served.
My lord, the respondents number 1 to 10 are being represented, my lord, by just take a moment of my lord, just one.
Yes, 1 to 10.
Mr. Rajiv Kumar Acharya, my lord, who appears for the OPs number 1 to 10. Well, kindly sees the affidavit.
Respondent number 1 to 10.
Yes. So,
Yes.
my lord, this matter, I'll tell you, my lord, what has happened, my lord.
Now, these government authorities, who is appearing?
Look, I don't think they are required to be made parties. They were parties in the suit, and therefore, my lord, they're still there. My lord, may I put this in a perspective, my
You
lord?
are representing
13 to 16. My lord, they
13
are
to 16.
13 to 16. My lord, they are sailing in the same boat as I am.
Okay, but so far as 1 to 10, it is represented.
My lord, that affidavit of service shows, my lord, one advocate had taken the copy of this, and Mr. Mr. Roy is appearing.
Yes, you are
Mr. Roy
appealing for opposite party number 1 to 10.
No,
Yes, 1 to 10 you are representing. Yes, you are for whom? 13 to 16.
13 to 16.
Yes, let us take up this application.
My lord,
Canta din can wanta.
I'm taking the plenary objection regarding the maintainability of this appeal.
Yes.
Maintainability of this appeal.
Okay. So you
my lord,
that is to be decided by the division bench.
My lord, may I put this?
Direct here, my lord, what happened is one of the defendant along with the others.
Is the second appeal maintainable? That is the question.
My lord.
Yes.
My lord, hears me for once before Mr. Roy's task, my lord.
Yes.
My lord, the appellant and the respondents number 13 to 16
yes.
were the defendants in a suit instituted by the respondents number 1 and 2.
Yes.
So respondent number 1 and 2 were the plaintiff, and my lord, the appellants, the appellant, my lord, and the respondents number 13 to 16 were the defendants.
No, you were the plaintiff.
No, my lord, I was one of the defendant.
Defendant appellant.
Yes.
Yes.
My lord, the respondent number 1 and 2 were the plaintiffs in a suit filed against the appellant as well as, my lord, the respondents number 13 to 16.
Yes.
Primary release were claimed against them.
Yes.
Now, what has happened, Milord? The suit was decreed.
Yes.
Appeal was dismissed, against which, Milord, a second appeal has been preferred.
Right.
That second appeal has been preferred by, Milord, the respondents number 13 to 16.
Yes.
That had been admitted and it's pending for hearing before this honorable bench. Now, Milord, during the course of hearing, Milord, what transpired was, despite, Milord, the appellant and the respondents number 13 to 16 all being arrayed as defendants and the first appeal being preferred by all of them, the name of the appellant did not appear in the memorandum of appeal. The name of the appellant did not appear in the memorandum of appeal. So that appeal was in effect, Milord, an appeal by the respondents number 13 to 16. This appellant was left out. Though, Milord, it's our case that he had signed the wakalatnama. Inadvertently, his name was left out. Now, Milord, when this appeal was, the earlier appeal filed by, Milord, respondents number 13 to 16 was taken up, Milord, it was discovered that the name of the appellant is not there. So that appeal, Milord, is not an appeal constituted by the appellant. So, Milord, we have taken out a fresh appeal. And, Milord, while taking out this appeal, Milord knows there's now been a considerable delay of 2,300 odd days since that appeal was pending. So this is an application, Milord, for condonation of such delay.
Yes. Have you taken out any opposition with regard to this application?
This appeal, why, my lord? This is the, my lord, can you consider order 40 rule 21?
No. Question is, if you want to object, you file your opposition.
This appeal, my lord, section 5 is the end of the
Okay,
appeal.
Whatever it is, whatever you want to say, you say it by way of opposition.
Well, record by, and if your lordship wants, well, this appeal is not maintainable. If that be so,
Okay. How many days delay?
2,135.
2393 was.
Well, can you consider order 40 rule 920?
Well, I'll place
The answer
that.
lies there.
I'll place that, Milord. I'll place
What
that.
prompted him to file this separate appeal?
Yes. Kindly seize order 20, 40
Yes.
rule 20, Milord. Let me place it. As to, Milord, why have I been constrained to prefer this instant appeal? You got it, Milord? Order 4120,
Yes. Order 41 rule.
rule 20,
20.
which my learned friend espouses, Milord.
Yes.
Milord, may I place it, Milord? Where it appears to the court at the hearing that any person who was a party to the suit in the court from whose decree the appeal is preferred, but who has not been made a party to the appeal, is interested in the result of the appeal, the court may adjourn the hearing to a future date to be fixed by the court and direct that such person be made a respondent. So, Milord, this is the provision. Now, Milord, may I place it once again for my lord's consideration? So, Milord, it should appear to the court at the hearing that any person who was a party to the suit in the court from whose decree the appeal was preferred, but who has not made a party to the appeal, is interested in the result of the appeal. Now, I pause here for a moment. Exactly, Milord, the case out here, that the presence of the Milord appellant here was necessary in that. Then, Milord, kindly see the most important part. The court may adjourn the hearing to a future date to be fixed by the court and direct that such person be made a respondent. Now, Milord, in my most respectful submission, Milord, the direction ought to have come from the court to make him a party. So the direction ought to have been passed by the court, Milord, who was in season of the appeal, to be made a party. If the court passes a direction, Milord, we would have definitely complied. And we could have. And if such a direction is passed, we would have.
The original suit
Yes, Milord.
before the trial court, you were one of the defendants.
Yes, Milord.
Appeal preferred jointly. Title appeal preferred jointly.
Yes, jointly.
Okay. Decree was passed against your client.
Yes.
So the appeal was preferred by the first appeal
Was preferred by me.
by you.
Me
And others.
and the other respondents of 13 to 16.
Very well. The others, it was preferred by you and the other respondents.
Respondents, that's 13 to 16.
Yes.
So, Milord, when
Thereafter,
the second appeal was preferred,
no.
That appeal, my lord, was dismissed
Dismissed on merits.
on merits.
But their necessary parties were before the court.
Yes. Now, my lord, in the second
That
appeal,
is, so all the parties before the trial court were the parties in
before
that.
the appeal court.
Very well.
Now, my lord, in the second appeal,
Yes.
all these appellants of the first appeal would have naturally been the appellants in the second appeal.
Yes.
What happened there was, my lord, one of the appellants, who is the appellant here, was inadvertently left out. My lord, this is bona fide inadvertence. Otherwise, my lord, there was no plausible explanation for the present appellant not to levy challenge to the appellate decree.
There is an alternative to that issue regarding if you are left out in this second appeal. There is an alternative remedy.
That remedy must be, my lord, pursuant to directions passed by the court. Kindly seize the language.
So, at any time,
No, yes, my lord, true. Kindly seize.
Order 1 Rule 10, you see, permits the court at any point of time to add necessary parties.
Yes.
My lord, but order 41, Rule 20, my lord, kindly seize. Power to adjourn hearing and direct persons appearing interested to be made respondents.
Okay, that means you, now the thing as it stands, that
Probably my learned friend did not produce the
now
order.
the thing stands that
I'll show everything.
the appeal was not preferred by you.
Yes, the appeal was, as it stands today, the records would reveal that the appeal was not preferred by me inadvertently.
Whatever it is, you are not an
Preferred.
appellant in the other appeal.
I bow down. So now, my lord, I intend to levy a challenge to that appellate court decree and the trial court decree which is merged, my lord. Now I prefer this appeal along with the delay of condemnation of 2393 days.
Okay, the appellate court decree was passed when?
My lord, the appellate court decree was passed, my lord. I'll just take a moment of my lord. The appellate court decree was passed on 29th of July 2017. 29th of July 2017.
And this is preferred in?
And my lord, this is preferred sometime in the year 2024. So, my lord, admittedly, and I say that there has been a delay of 2393 days. My lord, the delay is there, my lord.
So
I
when did you come to know?
My lord, I come to know about this, my lord, in the month at page 11, para 9, on 22nd May 2024. My lord, if the other court, my lord, who was hearing this second appeal, if that court would have directed me to be added as a respondent, my lord, there wouldn't have been any problems. In fact, my lord,
Last order. Last order.
So is the appeal pending before any other learned judge?
yes, second appeal.
Let both this matter appear together. Let me
Yes.
see the orders.
Apart from that, one can consider two provisions are there.
Yes.
It is that not order 1 Rule 10 and order 20. Court has to ask
Because you see, another thing is this, that appeal is admitted, the single bench is hearing.
hearing.
But so far this appeal is concerned, it is not.
That is
yet
why,
admitted.
my lord, can you consider power exercised under order 41 Rule 33.
Yes,
But that is subsequent to appeal being admitted.
order 41, rule 33.
33.
Yes.
The appellate court shall have the power to
Yes.
pass. What? Yes. Let me place. After that, yes.
I'm agreed to what my learned friend is saying. I'm agreed to that.
Then, my lord, if 10 defendants prefer a title appeal, the 10 separate appeal will be filed.
No.
Why? Same analogy will apply.
Power of the, yes.
Make any order which ought to be passed or made by the passer for the orders as the case required. And this power may be exercised in the court notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or parties. Although such respondents or parties may not have filed any appeal or objection. You are representing the estate, jointly preferred an appeal, subsequently you withdraw or did not prefer an appeal, whether it is intentionally or not, that is, I am not on that. Because, my lord, today the same person is coming and filing a separate appeal. Whether this appeal is today, my lord, if this appeal is dismissed, and this appeal can be maintainable.
If a separate appeal can be filed by the parties who have suffered a decree, then
Yes, that is precisely, that is my point. Whether this appeal, two separate appeal,
it can be no. The separate appeal
Can
can be
be-
filed.
when they chooses to contest the appeal, that is why your logical is considered Order 41, Rule 22. Order 41, Rule 20. No respondent shall be added. My Lord Kaligongas, this amendment was carried forward in the year 1977. No respondent shall be added as this rule after expiry of the period of limitation for appeal unless the court is the reason recorded allows to be done on such terms and conditions things fit. So it is the duty
Lord,
as
this-
casted upon the court also.
Yes, so
No, you
that
have to
issue,
the same. You have to, the
I
court
bow
must
down, no,
decide.
my lord.
Whether is that application?
This issue ought to have been, my lord, this direction ought to have been passed by the learned judge, my lord, who was hearing that second appeal.
Anyway, your objection is only on the ground of maintainability, relying upon Order 41, Rule 20.
Apart from that, Order 41, Rule 33, the appellate court degree will encompass all the persons who are party to these proceedings.
My lord, may I respond to this, Order 41, Rule 33?
Yes.
May I respond, my lord?
Yes.
My lord, I pose this question to myself, my lord, whether in a suit, if there are two defendants and the suit had been decreed, whether separate appeals are maintainable at the instance of two different defendants. But the answer to this is an astounding yes. So, my lord, if two appeals are maintainable, or if different appeals are maintainable by different defendants, my lord, then I don't see any plausible explanation as to why this appeal is not maintainable. Number one. Number two, as I say, my lord, the provisions of Order 41, Rule 20, if my lord kindly sees it, the direction ought to come from the court. Kindly sees the language. The court may adjourn the hearing to a future day to be fixed by the court and direct such person be made a respondent. The language is not this on an application made or at the behest of the appellant or at the behest of the party left out. Because, my lord, I'll tell you the reason why. The reason is very obvious, my lord. The person who was not a party in that appeal cannot make an application in that appeal until unless he's added. This is what, my lord, the language of Order 41, Rule 20 says. The court must direct. Obviously, my lord, having revert to the provisions of limitation. That is there. But this exercise, my lord,
To be done by the court.
has to be done by the
If
court.
it is on the either suo motu
Well,
basis of application.
I bow down.
my lord, can you consider? Then, my lord, can you consider Order 26, Rule 9, the language, with my learned friends, and if that is the law, that is the power given to the court, my lord, can you consider Order 26, Rule 9? In any suit in which the court deems a local investigation to be requisite for the purpose of elucidating any matter in dispute or ascertaining the market value of
Yes.
any. This is the court satisfaction. Then, my lord, why this application has to
But
be
may I
filed?
put this
There
question
shall not
myself?
be no use of filing of
My lord,
petition.
my
It's
lord,
the enabling power
lord.
given to the court.
There's a difference, my lord. In Order 26, Rule 9, my lord, all the parties are before the court. My lord, under Order 41, Rule 20, the person who requires to be added is not present before the court. Therefore, the court has to direct his presence. The court has to direct that such a person be made a party.
Yes. What was the decree passed by the trial court?
My lord, the decree passed by trial court was the suit was decreed, my lord, in the sense that a challenge
To
was
your
laid.
prejudice?
Yes, to my prejudice. Yes.
Yes. What is the
My lord, there was a deed which was challenged by my learned friend's client.
yes?
That deed was executed by their predecessor in my favor. In fact, by them in my predecessor's favor. So, my lord, the deed was the bone of contention. If that deed has been declared to be void, so, my lord, their rights have been protected. On the contrary, my lord, if that deed was held to be genuine, my lord, I would have laid my claim to the property. So I was affected. There's no doubt about that. In fact, that is the reason, my lord, why I levied the first appeal. The first appeal was levied by all my lord, the appellants as well as 13 to 16. It was only by mere bona fide inadvertence, my lord, that the name of the present appellant was left out in the memorandum of appeal.
In the second appeal.
Yes.
That is why precisely I am placing before lordship. What is the wrong in placing the application before the court? Yes, this is the person who has been left out. If I could not understand, it is not brought to the notice of the court.
If this is what my
If
learned
that-
friend's
if that
contention
is
is,
so,
my lord,
So
if-
that appeal is incompetent.
my lord, may I put it this way, my lord? My lord, that appeal is not incompetent. my
Yes.
lord. That appeal is
Anyway,
competent.
that is
where-
not for him to say, that is for those appellants.
Yes.
So that is why
That appeal, my lord, is not incompetent. That appeal is competent where the respondents number 13 to 16 out here, because that appeal has been validly levied by, my lord, respondents number 13 to 16. It's only that this appellant's name did not figure in the memorandum of appeal that he has come up with this. And if my learned friend says that they need to prefer an application, my lord, if that is what he says, my lord, I go there and can you keep this pending? I go there for an application, come back. If this is what my learned friend says, I go there and kindly adjourn it for a fortnight. I go there, make an application on the basis of my learned friend's submission at the bar made today, my lord. I go there. Well, I need my rights to be protected, whether here, but I can't have a choice of forum, either here or there.
Yes, anything else to add?
yes, let him file their application over there.
Well, kindly record this, my lord, and kindly post this after a fortnight. I'll try my luck and come back, my lord.
Or my lord can place this matter along with the same. Will be heard.
Leave it to your lordship, my lord.
No, no,
Yeah,
is the matter part heard before his lordship?
Yes.
Oh, then
No, as no,
My
no,
lord, we need to check.
told you though. Hearing is continuing, but not Parker in a
Not
regular bench.
Regular bench. my
Regular bench.
lord. Now that I leave it to your lordship, whether my lord would permit me to go there, exercise my lord, my jurisdiction, come back out here, my lord, and post this after 15 days. Or my lord, post this before my lord, the other bench.
whatever both of you decide, you decide.
My lord, then my lord,
If you want me to decide your application on merits, whatever it is, I can decide.
my lord takes after a fortnight. If this is what my learned friend says, then I can go and try my luck out there. In the meantime, kindly my lord adjourns for 15 days. If this is what my learned friend says.
Yes, Mr. Rai, what do you suggest?
As a lordship. My argument is that there is a provision, you is joint appellant, you have to go and prefer an application that is his party has been left out. Subject to my lord's.
Yes, record an order. Learned advocates for the parties are present. The application for condonation of delay is taken up for consideration. Heard learned advocates for the parties produce the petition file. The objection raised by the learned counsel for the opposite respondent number 1 to 10. 1 to 10.
11 to 13 is there.
1 to 10.
13 to 16.
1 to 10, Mr. Rai, is that this appeal is not maintainable in view of the provisions contained in Order 41, Rule 20 of the Code of Civil Procedure. Learned advocate for the appellant disputes the submission and relies upon the provision contained in Order 41, Rule 33 of the
Rule 20. I learned 20.
Oh.
Both of us learned 20. My lord. The interpretation is
Order
different.
41, Rule 20 of the Code of Civil Procedure and submits that on the defect being pointed out by the court hearing the appeal, necessary steps can be taken for addition of parties. And in the instant case, no such order was passed by the learned court who was hearing, this appeal. Learned advocate further submits as the parties who have suffered a decree can maintain a separate appeal. This appeal is not barred by law and only it can be heard upon condonation of the delay. Upon hearing the learned advocates and upon considering the facts of the case, this court is of the view that the appellant should be granted a reasonable opportunity to make necessary application before the pending appeal, which is being heard by a learned coordinate bench of this court regarding addition of parties. Thus, without prejudice to the rights of the parties, this matter stands adjourned till, I'm keeping it in the month of January.
Yes, 5th is the date fixed, so they can take steps.
Fifth is
5th December is the date fixed for hearing of that appeal. And there the Honorable Court categorically directed.
no, I'm keeping it in the month of
Then
January.
there is no problem. So there is no
Matter appear on 6/1/2026.
grateful to
I'm grateful, my lord.
No, dispose হয়নি 6/1/2026 to appear.
Item number 5 and 6, my lord. This is, my lord, coming up at our instance. The interim order is to expire, my lord, on
No, what-
29th of November.
Question is, what is this matter about?
This is, my lord, a second appeal passed, my from a challenging, my lord, and
FMAT.
yes, FMAT numbered as FMAT RERA, but is effectively a second appeal, my lord. It was admitted as such. The reason being, my lord, there was an order initially passed by the
So
competent
it was
authority.
admitted by the division bench.
Yes. And then an interim order was passed. The interim order has been extended from time to time. It is there till 29th of November.
Yes, record and order.
Grateful.
Learned advocates for the parties are present as the interim order passed by the Honorable Division Bench is going to expire on 29th November 2025. The interim order stands extended till 22/12/2025 or till further orders, whichever is earlier.
May it be from the first week of January, then, my lord.
Extended till 6/1/2026 or till further orders, whichever is earlier.
My lord is pleased to keep the matter on any particular date.
6/1/2026.
The matter will appear on that date,
Yes.
my lord. Very well.
Let this matter appear on 6/1/2026 under the same heading.
Grateful.
The opposite parties be informed.
Grateful, my lord. I will.
Lordship, Mr. Kishore Mukherjee is for the petitioner. I am praying to your Lordship for a short passover. He is on his legs before court room number 16.
You are for?
And for the respondent number 124.
Okay, not today.
Grateful.
Not this week, my lord. Not this week. Over telephone.
Okay, not this week.
Grateful, Lordship.
My lord, I have come before your lordship by challenging a judgment dated 19th of December 2024, passed in MACC matter. The direction of the paper book may be passed, my lord.
Yes.
We will prepare the
Opposite parties have appeared.
No, my lord, notice may be issued, my lord.
Okay, so
Shall
let notice of appeal be issued
Yes.
first.
And,
Yes, record an order.
my lord, we will prepare the informal paper book, so LCR may be called for, my lord.
No. Question is, let the opposite you serve notice of appeal first. Thereafter,
Very well.
learned advocates for the appellant is present. Let notice of appeal be served upon the respondent through the department. Let this matter appear on 7/1/2026. Let the trial court records be called for. Let the trial court's record
Trial
come, then
court,
only you can prepare the paper book.
Yes, my lord. LCR may be called for.
Yes, let the trial court's record be called for.
Special messenger cost will.
Let the trial court's record be called for at the special messenger cost
Messenger
to be
cost.
paid by the appellant.
Yes, my lord. Grateful, lord.
Your lordship, I beg to appear for the respondents.
9. 9, you are for the respondents.
The respondents.
You are for appellant. No. Item number 9, right? Appellant is the National Insurance Company. Okay, the matter. Oh, this is happening for what? Correction? কি correction আছে?
নামটা বলে দাও এখানটা লিখে দাও
They disposed. Yes, what is the mistake to be rectified?
আমার কিছু না
Lordship,
কি আছে ওখানে মিস্টেকটা কি হয়েছে?
on order 6,
আমার তো কোনো correction নেই।
দেখি কি অর্ডার কি আছে?
নামটা এটা লিখছি।
না অর্ডার শিটের সাথে বলছে যে কস্ট টাইটেল মিলছে না। দেখি কি আছে কস্ট টাইটেলটাতে আছে আপনার ন্যাশনাল রূপালী কোথায় রিপোর্টটা কোথায়? না কষ্ট এই যে 19/11। মানে অ্যাপেলেন্টের জায়গায় ইন্স্যুরেন্স কোম্পানি না দিয়ে ন্যাশনাল ইন্স্যুরেন্স কোম্পানি লিমিটেড। হুম। The appellant, instead of insurance company, it should be a national insurance company limited. Yes, record an order.
Your Lordship, my humble submission is that kindly fix a short date for hearing in this matter, Lordship. The claimant.
Just a minute, I'm rectifying this matter. This learned advocates for the parties are present. This matter is put up for necessary rectification by order dated 19/11/2025. In paragraph 2, it is mentioned appellant stroke insurance company, as and the same was also made in paragraph 3 and paragraph 1. Thus, instead of insurance company, let it be recorded as National Insurance Company Limited. Other contents of the order dated 19/11/2025 remain unaltered. So I granted liberty to mention. So after the paper books have been filed.
Your Lordship directs us, then we can prepare the proposal. Your Lordship directs us.
Okay, you just, as the matter is ready for hearing, now as the trial court records have come, trial court record is she?
No, no,
Huh?
no.
Trial court, the trial court's record be called for at the special messenger cost of the respondent number 1.
Respondent.
Number 1. As this is a claim case and there is a chance of settlement, let this matter go to the National Lok Adalat to be held in the month of December. Fixed 7/1/2026.
For the National Local Lordship, we
Yes.
don't have instruction. Let us come back.
No, if you don't have instructions, you may not settle, but I'm sending the matter. If you get instruction, you settle. Otherwise, I'll take it up on 7/1/2026. Let this matter appear on 7/1/2026 for report of the Lok Adalat. If it is settled, well and good. Otherwise, I'll hear the matter.
Grateful.
যদি কোনো কিছুতে সেটা যদি কোনো
Grateful.
Then, I'm praying for a very short passover. The
Okay.
meeting notes is getting stitched, man.
So maybe the fixed after 2 p.m. Maybe the fixed because one already the running my the listed 28 code
I'm
number.
again not today.
Not today, not. The fixed maybe 2 p.m. I'm
2
prepared.
PM, he's praying.
2 p.m. my lord.
Matter may be fixed at
2 p.m. I think 3 p.m. there is another fixed matter.
Okay. 10 minutes.
So just I'm making it
Short pass.
okay. Short pass.
Grateful to you.
11, I am appealing for the petitioner. Well, I have challenged an order passed in connection with a proceeding under section 138 of the Negotiable Instruments Act. Well, this is a proceeding where initially the complaint has been filed, plea has been recorded. At that juncture, the complainant came up with an application under section 143A. Now, parallelly, there was a proceeding pending before the Insolvency and Bankruptcy Court. In that Insolvency and Bankruptcy Court, during the pendency of this 143A application, moratorium order has been passed against the company. Therefore, consequently, Millard, in terms of section 14 of the Act, the May I continue, Millard? Millard, may I continue, Millard?
Yes.
Millard, in terms of section 14 of the Act, the proceeding cannot continue so far as the corporate debtor, that is the company, is concerned. At that juncture, an application was also filed. Learned magistrate allowed that part, kept this proceeding abeyance in respect of the company itself. The petitioner therefore preferred a revision against the order, against an order, praying for that this direction for this 143A interim compensation cannot be passed against a director, because the direction under section 143A is primarily in respect of the drawer, in respect of whom, in view of a restriction order passed by an IBC and the Supreme Court judgment, there cannot be a proceeding. So he prayed for setting aside of that portion of the order of directing the director to make the payment. Learned Sessions Court.
Question is, you see, the appeal preferred by, I think, the present petitioner,
My lord.
Agarwal,
My lord.
is not appeal, this is the revisional
Revision, my lord.
application. That was dismissed.
My lord. Against that order, my lord, I have preferred a revision before the Learned Sessions Court.
Yes, so
Learned,
that is dismissed.
that is dismissed.
So not that it was set aside.
No, my lord, it was not set aside. So I have come up against that order of rejecting my application by this Learned Sessions Court. And my lord, I am squarely covered by a decision passed by the Honorable Supreme Court, where in identical situation, the similar order, similar situation was propped up, and the Honorable Apex Court categorically held that no 143A order can be directed to be executed and be passed so far as the directors are concerned, because they are not the drawer of the check. The drawer of the check is the company. My lord, the learned, astounding, my lord, if your lordship sees the order passed by the Learned Sessions Court, your lordship will find that this judgment, which I am relying upon before your lordship also, has also been placed before the learned judge. Now, the learned judge firstly tried to distinguish the judgment, that this judgment was passed at a subsequent stage when the order for 143A has been passed. So it has no retrospective effect. But with deepest respect, Millet, a judgment is only interpreting a law. It's not saying that it introduces a law. Until and unless it is said to be a prospective by a prospective overruling, the judgment is always holds the law which is there, and it has a retrospective effect. Secondly, Millet, the way he has distinguished the judgment, that is completely unheard of, and an attempt to overreach an order passed by the Honorable Supreme Court. If your lordship so pleases, Millet, I can hand over the judgment of the Honorable Supreme Court, Millet, if your lordship kindly look into this, Millet.
Yes, paragraph.
My lord, it starts from paragraph 29 onwards. If your lordship be kind enough to, prior to that, kindly come to paragraph 17, Millet. Paragraph 17, Millet. The principles of 141, 143A, everything has been narrated.
17.
Paragraph 17, Millet.
Yes, before we delve into the argument.
Yes, Millet, that is the observation portion. Should I continue reading here from Millet?
Yes.
Before we delve into the argument presented by the counsels for the parties before us, it is imperative that we also look at the observations made by the High Court with respect to two judgments heavily relied upon by the parties before it as well as before us. The High Court, while addressing the reliance placed upon Anita Hada versus Godfather Travels and N. Harihara Krishnan, observed that while Anita Hada underscored the necessity of involving a company as an accused to maintain a prosecution under Section 141 of the NI Act, N. Harihara Krishnan clarified that an authorized signatory is not considered as a drawer under Section 138 of the Negotiable Instruments Act. These judgments guided the High Court in interpreting the provisions of the NI Act 1881 regarding vicarious liability and definition of the term drawer with the statutory framework. Then, Millet, the submissions of the appellant has been recorded, what has been submitted. Then, Millet, submissions of the respondents have been recorded. If your lordship kindly come to paragraph 28. The High Court's interpretation, may I continue, Millet? The High Court's interpretation of Section 7 of the Negotiable Instruments Act accurately identified the drawer as the individual who issues the check. The interpretation is fundamental to understanding the obligations and liabilities under Section 138 of the NI Act, which makes it clear that the drawer must ensure sufficient funds in their account at the time the check is presented. The appellant's argument that directors or other individuals should also be liable to Section 143A misinterprets the statutory language and intent. The primary liability, as correctly observed by the High Court, rests on the drawer, emphasizing the drawer's responsibility for maintaining the sufficient funds. The general rule against vicarious liability in criminal law underscores individuals are not typically held criminally liable for the acts committed by the others unless a specific statutory provisions extended such liability. Section 141 of the NI Act is one of such provisions extending liability to a company's officials for the dishonor of a check. The appellants attempt to extend this principle to Section 143A to hold the directors or other individuals personally liable for interim compensation is unfounded. The High Court rightly emphasized that liability under Section 141 arises from the conduct or the omission of the individual involved, not merely their position with the company. The distinction between the legal entities and the individuals acting as an authorized signatory is crucial. Authorized signatories act on behalf of the company but do not assume the company's legal identity. This principle, fundamental to corporate law, ensures that while authorized signatories can bind the company through their proposed actions, they do not merge their legal status with that of the company. This distinction supports the High Court's interpretation that the drawer under Section 143A refers specifically to the issuer of the check, not the authorized signatories. The principle of statutory interpretation, particularly in relation to Sections 143A and 148, was also correctly applied by the High Court. The court emphasized that when statutory language is clear and unambiguous, it should be given its natural and ordinary meaning. The legislative intent, as discerned from the plain language of the statute, aims to hold the drawer accountable. The appellant's argument for a broader interpretation to include the authorized signatories under the Section 143A contradicts this principle and would lead to an
Anyway, this view is not accepted.
My lord, this view is not
accepted by the trial court, not by the appellate court.
Not by the appellate
By
court.
the revision.
By the revisional court, my lord.
Yes, record an order. Learned advocate for the petitioner is present. This application under Section 528 of NSS. This application under Section 528 of the BNSS 2023 corresponding to Section 482 of Code of Criminal Procedure 1973 is directed against order dated 4th December 2024 passed by the learned Additional District and Sessions Judge, Fast Track Court, Calcutta, in connection with Criminal Revision Number 30 of 2024, arising out of complaint case number CS/7211/2020 under Section 138/141 of the Negotiable Instruments Act 1881 and affirming the order dated 27th February 2023 passed by the learned Metropolitan Magistrate 16th Court, Calcutta, now designated as learned Judicial Magistrate 18th Court, Calcutta.
16th Court.
It was by learned Metropolitan Magistrate 16th Court.
16th Court, now designated as the
designated as learned Judicial Magistrate 18th Court.
Not 18th Court. It is 16th Court.
Anyway, let it be 16th Court. Learned advocate for the petitioner submits that the learned trial court as well as the court exercising power under revision are in not accepting the decision of the Honorable Supreme Court in the case of Vikram Nath and Prashant, in the case of Sri Gurudatta Sugars Marketing Private Limited versus Prithviraj Sayajirao Deshmukh and others, reported in 2024 SCC Online SC 1800. Learned advocate submits that when the company of which the petitioner accused is the director has gone for liquidation, for revival under the IBC code 2014, the allegations against the petitioner accused is not maintainable. Learned advocate draws attention to the observation made by the learned additional district and sessions judge, fast track court number 1, wherein the learned judge observed that the decision of the Honorable Apex Court was passed on 27/2/2023. Now, was passed on 24/7/2024. 2024, and the impugned order, which is under challenge, is passed on 27/2/2023. Upon perusal of the decision of the Honorable Apex Court in the case of Sri Gurudatta Sugars Marketing Private Limited, it appears that the Honorable Apex Court has made the following observation, distinguishing the liabilities in case of dishonor of check with regard to the persons who are authorized signatory and the persons who are drawers of the check. The observation made by the Honorable Apex Court are as follows, set out para 29 and 30. So your case was this present direct, the accused person is not a signatory to the check, drawer of the check.
He is a signatory to the check, but
Yes.
the drawer is the company because he signs on behalf of the company.
Okay. As this case stands on the ground that the signatory to the check cannot be made accused as he is not the director.
Cannot be made liable for
cannot be made liable for the dishonor of the check.
Cannot be made liable for the, well, subject to correction, for the payment of interim compensation.
Okay, for the payment of interim compensation, as the principal accused is the company.
My lord.
Upon hearing the learned advocates and considering the facts of the case, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week, an affidavit of service filed. Let this matter appear on 22/12/2025. Pending hearing of this application, there shall be a stay of further proceedings before
Learned judicial magistrate, 16th court.
Learned Judicial Magistrate, 18th Court, Calcutta.
16th court, millet.
Oh, Learned Metropolitan Magistrate.
Learned Metropolitan Magistrate, now designated as a Learned Judicial
Learned
Magistrate.
Judicial Magistrate, 16th Court, Calcutta, in CS 7211/2020 for a period of 1 week from the date of reopening after Christmas vacation.
Extremely grateful. There is a mistake in the cause title. Kindly grant me leave to.
The cause title may be rectified by the learned advocate.
Wait, please, Your Lordship. I am praying for only innocuous fair, expeditious direction to the learned court.
No, no, is it a
What?
NI Act?
No.
No, then this court does not have determination. Only this court is assigned with the determination of NI Act. If it is NI Act, I can direct expeditious
No,
disposal.
there is
Urgent determination.
urgent
Yes, with regard to NI
Determination?
Act, not any other matter.
Oh, sorry.
There is other bench, you try there.
I-
So yes, record an order. As this bench is not assigned with the determination, the matter stands released from this list.
As you lordship.
And the matter may be placed before the bench having determination.
Appropriate. Grateful.
Well, at 13, I am appearing for the petition. It's a NI Act matter. In this matter, I am humbly praying only for a direction to serve upon the accused person. Here I am the complainant. I have come up for enhancement of the sentence. He was convicted in 138 proceeding. He preferred an appeal.
What is the ground for enhancement?
My lord, the London Sessions Court, while dismiss the appeal, hold that there is nothing to interfere with the sentence, but he removed the substantive sentence. Only the fine portion kept, and in default a sentence of 2 months. Before the London Magistrate Court, there was a direction for the substantive sentence of 1 year along with a fine of rupees 44 lakhs. In default, with a default clause.
Okay, this is let me see the order of the appeal court.
My lord, this is a part of the certified copy, my lord. Your lordship will find it after page 83.
Yes, which ordering portion? Yes.
Yes, my lord, kindly come to second last page. Inner page 10. My lord, kindly see the observation starts from the paragraph 67 middle portion. Additionally, there is no evidence of mitigating circumstance such as bona fide payment of the debt before the judgment, unexplained delay attributable to the complainant, or any other factors that typically warrant leniency in sentencing. The appellant's failure to present mitigation leaves the court no option but to uphold the sentence imposed. This is the observation made by the learned appellate court. Now, the learned court is continuing. The 68 imposition of sentence in accordance with judicial trends and statutory mandates. The sentence pronounced by the trial court balances the twin objectives of the retribution and deterrence. The punishment meted out is consistent with the authoritative pronouncement by higher courts emphasizing punishment proportionate to the gravity of the offense under section 138. Moreover, the restitution ordered, the return of the check amount to the complainant conforms to the remedial purpose of the legislation, enabling recovery of the actual financial loss suffered. This dual focus ensures not only penal consequences for the offender, but also equitable relief for the aggrieved party, vindicating and the legislative intent underlying the Negotiable Instruments Act. Having carefully examined the entire materials on record and the submissions advanced by the learned counsel on both sides and relevant statutory provisions and judicial precedents, this court finds no legal or factual infirmity warranting interference with the impugned order of conviction and sentence. The arguments raised by the appellant have been thoroughly considered but fails to establish any credible ground for reversing or modifying the decision. Now, I should kindly come to the order portion. After making this observation, the learned appeal court.
Regarding the payment, this is also under NI Act.
My lord.
So you have received the amount?
No, nothing, my lord. And my lord, in fact, they did not deposit the mandatory portion. That order is not there, so I cannot place it before this order. My lord, learned appeal court considered that there is nothing to interfere with the sentence and conviction. There is no scope of showing any leniency. In spite of that, he removed the sentence.
Anyway, this will be admitted upon hearing the other.
My lord. I am praying for service.
Yes, record an order. Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. Peruse the order passed by the learned appellate court in criminal appeal number 154 of 2024. This matter can be taken up for consideration with regard to admission in presence of the opposite parties. Let notice be issued upon the opposite parties within 1 week and affidavit of service be filed. Let this matter appear on 22/12/2025.
Extremely grateful.
I appear for the petitioner, my lord.
Opposite party, your lordship.
Pursuant to lordship's direction, I have served, my lord.
For the opposite party, I'm paying for not this week, your lordship.
This is an assigned matter.
Yes.
The matter, the revisional application is admitted.
Yes, admitted. My lord was pleased to pass an interim order in this matter, my lord. I will be humbly praying for extension of the interim order.
So when it will expire?
This week, my lord.
So you are seeking what? Only not today?
Not this week, your lordship.
Only not this week.
Next week, I have some personnel kindly keeps thereafter any day fixes the matter. The short
When
issue.
is the matter fixed? Before the trial court?
Today is fixed, my lord.
Anyway, interim order is continuing.
Kindly extend for the time.
Okay, record an order. Learned advocates for the parties are present on the prayer of the learned advocates. The matter is fixed on. Next week you have some difficulty.
Yes.
On 9,
my lord.
12/2025, the interim order granted earlier shall continue for a period of 4 weeks or till further orders, whichever is earlier.
Affidavit of service be kept with the record.
Affidavit of service file be kept with the record.
Deeply okay.
For 17.
17.
17, I'm appearing on behalf of the respondent insurance.
Lord, here I am for the appellant, my lord. And there is two can. Can number 1 is for attainment of majority. 2 to 5 became major and sui juris, their name should be as major. And another is, I have filed the annexed page number, my lord, kindly see page 6, 7, 8, 9, 4 other cards. And number, can number 1. Okay, file হয়েছে?
6924.
6924 it was filed. Kindly see page 6, my lord. Annexure A 6, 7, 8, 9. Annexure A, which is 4 other cards of the claimants.
Okay.
And the annexure E also the Pradhan certificates regarding the
So according to you, these appellants have attained majority.
Yes, my lord.
That means appellant number?
Appellant number 1 to claimant, mother.
1 is the widow mother.
Widow.
So 2 to 5.
2 to 5, yes, my lord.
Yes, record an order.
My lord, I
My
object
lord,
to
another
this.
thing, another can 2 also there.
No, can 1.
I object to this can 1 because this matter, my lord, will see the number of orders in this matter. My lord, it was dismissed initially by the tribunal because the relationship between the claimants and the deceased, one Hassan Ali Mukami, that was in dispute. This application, it needs to be heard. And today it came up suddenly. I also could not get prepared.
This application.
It has to be heard with the main appeal. My lord will kindly see the number of orders in it.
Let the majority be recorded.
That cannot be done because whether at all these claimants, they are.
So you want to file objection to this application, then you file it. I shall hear
My
it.
lord will hear me out once. My lord will fix up a date because these applications, they have to be
Paper
heard.
books are ready.
Yes, he has given me a copy.
Paper book has already.
He has given me a copy.
No question.
All
You
these,
see,
they have to be heard
see,
together.
Let this matter, this majority be recorded. The main point of objection, with regard to merit, will be kept open at the time of hearing.
Then my lord will kindly take it up tomorrow. Let me just go through this brief once more because the facts are very complicated.
Okay, not today.
Not today. Grateful, my lord.
It will be tomorrow, my lord.
Not today.
Number 18 and 19.
This matter, I am for respondent cross objector, my lord. My lord, learned advocate for appellant, Mr. Purimal Pahari is absent due to his broken.
Okay,
Kindly,
not today.
not today. Well, kindly fixed for tomorrow.
Just making it not today.
Much obliged.
Twenty.
In this matter, I am for the Union of India, my lord.
My lord, I appeal for the appellant, my lord. My lord, very short point involved, my lord. Only the disbursement, not on quantum, not on dispute, everything is settled. Only on the disbursement of the claim amount by the tribunal, my lord. This is the very short
So
point.
what is the application here?
Application is, my lord, the subsequent to the filing of the appeal, the claimant has filed complied the order, my lord. So since he has complied, the amount this appeal should have been made, in fact, was the amount should have been paid, my lord. But that also has not been
Question
paid.
is, you are the appellant.
I am the appellant, my lord.
So pursuant to preferring of this appeal, the Union of India has made the payment.
Has not made the
Has
payment.
not made the
Has
payment.
not made the payment.
May I most respectfully submit before your lordship regarding the question of maintainability of the appeal.
Yes.
In view of the fact that the direction was given regarding the payment by the rail authority, but we have not been given the requisite documents for which the payment is to be made. That is to say, PAN card.
Where is the direction upon the authority to make payment?
Yes,
My lord,
order
it's
is
not
there.
impugned.
Where?
And order was passed on 29th of January 2019.
29th of January 2019. By the trial court.
By
the claim, railway claim tribunal.
Yes, that's the trial
Trial
court tribunal.
Yes.
So against that, the appellant has come being not satisfied.
Being not satisfied, probably.
Yes.
But my respectful submission before your lordship is that regarding payment, making payment, disbursement of the payment,
Yes.
payment amount, certain documents are required.
The fate of this appeal. First of all, this appeal is pending. This appeal has to be disposed of.
Yes, but my respectful submission before your lordship that the payment cannot be made because of the fact that the PAN card and the mandate have not been given to us, for which we cannot start our process of payment.
Where is the scope of payment now? Because appeal
Because
is
in view of that, the petitioner, I mean the appellants, move before the appropriate forum against which the appeal has been preferred before your lordship for execution of the order. In fact, we cannot proceed with the payment since the documents have not been given, and we want to give affidavit to that extent.
He is coming against the order dated 29/1/2019. Okay.
2019. Till date, no document has been given to us.
The claim was allowed. Okay.
Yes.
So
the operative portion, my lord. Kindly come to the page 5 of the operative portion, my lord. The from the second para of the operative, it is ordered that out of the decreed amount, award of favor of each claimant, 75% should be deposited in their separate savings bank account or scheduled bank account in fixed deposit scheme for a period not less than 5 years, with liberty to the accountant holders to withdraw the interest accrued on such deposit periodically. This part. Second part, money of such deposits will not be permanently released to the without reference to the order of this court. Number 3, the claimants are directed to submit their separate savings bank account particulars opened with any nationalized bank situated nearby the residential address as per mentioned in the Aadhaar cards, election identity cards to the respondent. And the respondent is directed to satisfy the decree within 16 days from the date of judgment through ECS, failing which the claimant shall be entitled to interest at the rate of 9% per annum from the date of default till the date of actual payment. They are also directed to obtain death certificate of the deceased before release of the compensation amount, as the same is not filed by the applicant. My lord, this part has the fourth point has been complied with, which has been my learned friend has perhaps been maybe misled by his client, my lord, because we have submitted the mandate form, my lord. Mandate form, and by maybe I have also I have affidavit to the extent, my lord.
This is the
mandate
order of the trial court, but what is this appeal for? You have preferred this appeal.
I appealed because my contention is that once the order is passed, the trial court becomes functus officio and has no capacity to direct as to the way of disbursement of the claim amount, awarded amount. It is a
But
beyond
no,
the jurisdiction.
you have assailed the order of the tribunal before this court.
Before this court on to that limited extent.
Limited to which?
Limited to paragraph 2 to 4.
Paragraph 2.
The ordering portion, paragraph 2. Which directs us to disbursement of the order at page 5 of the impugned order.
Yes. Paragraph 2, it is further ordered that out of
claimant is each claimant 75% should be deposited in their separate savings bank account or scheduled bank in fixed deposit scheme for a period of not less than 5 years, with liberty to the account holders to withdraw the interest accrued on such deposit periodically. This part, money of such deposit will not be permanently released without reference in the order of this tribunal. Number 3, the claimants are directed to submit their separate savings bank account particulars opened with any nationalized bank, scheduled bank situated nearby their residential address as mentioned in the Aadhaar card, election identity cards to the respondent railway immediately for payment. And the number 4, my lord, number 4, what he is submitting, I am contradicting, and I have document to show that the respondent is directed to satisfy the award within 60 days from the date of judgment of the through ECS, failing which the claimants shall be entitled to interest at 9% from the date of from the date of default till date of actual payment. They are also directed to obtain death certificate of the deceased before the release of compensation, as the same is not filed by the applicant, my lord. My lord, this part, my lord, what I need to say for ECS payment, I need to submit the ECS form. My lord, that has been submitted, and on receipt, my lord, I have receipt, my lord.
What is your ground of challenge in this appeal against
the trial court has no power, the learned tribunal. My point is that learned tribunal has no authority to direct how the amount will be disbursed by the claimant, my lord. This is a limited period, limited scope of the appeal.
So this is the grounds of appeal.
This is the ground of appeal. Once the award is passed, my lord, the trial court becomes functus officio. Beyond award, it cannot go. And it is also settled, my lord, by this by coordinate bench of this honorable court, my lord. It may not trouble your lordship much, my lord. If my lord goes to this order, my lord, this order is on the same point, my lord, similar situation.
Lord, may I respectfully submit before your lordship?
Yes.
That in connection with the submissions made by my learned friend, we want to use affidavit as we have been instructed to place before your lordship regarding the facts for which disbursement of payment amount cannot be cleared.
Affidavit to which application?
In connection with CAN 2 of 2023.
CAN 2, what is, let me see what is CAN 2.
Yes, CAN 2 is payment of 9% interest, penal interest.
So if you want this application to be heard out, your learned friend should be given an opportunity to use an affidavit.
Yes.
So let him file an affidavit in opposition.
My lord, one thing, my lord, may I pray, my lord, the CAN 2 I need to substantiate because at the time of when the Can 2 was affirmed, my lord, the document was not was not annexed to the document.
To
What
file
he
a
is
supplementary affidavit.
supplementary is ready, my lord. May I file it with with
Yes,
giving him a
yes.
copy?
Yes, record an order.
And may I be permitted to give, to allow 2 weeks' time to file affidavit?
Yes, learned advocates for the parties are present. Are learned advocates on Can 2 of 2023. Let the supplementary affidavit file be kept with the record and copy be served. Learned advocate for the respondent Union of India prays for time to file affidavit in opposition. Such prayer is allowed. Let affidavit in opposition be filed on or before 10 12 2025. I'm keeping it 2 weeks 10 12. Reply if any by 17 12 2025. Let this matter appear on 6 1 2076. Yes, 6 1 2026.
My lord, let it be 7th, my lord.
Yes,
So, my lord,
Let it be 7.
7 1
my lord,
2026.
on 7th, my lord, I have some sort of difficulty, my lord.
Then after
Kindly
any
fix
date
any date
after 7th.
after 7.
8
8.
8 1 2026.
Two.
Under the same heading.
Same heading.
My lord, 2 weeks, 1 week, my lord.
Yes, by
But
10
when it is
by,
expiring, it is
by 10th of December you file your affidavit in opposition.
My lord.
You will file it by 17th of December. So it will appear after
On eight.
vacation. 7 1 2026.
deeply.
8 1 2026.
My lord, deeply.
21.
21, Lordship, I am for the appellant, Mr. Roy appearing for the respondent's Lordship, insurance company. This is the only issue involved in the appeal, the issue of quantum Lordship. He has paid for Lordship 15,000 per month. He was the labor of the big field. The learned tribunal considered rupees 5,000 per month, assess the compensation accordingly. And Lordship's second fold of submission before your Lordship only is that the learned tribunal did not consider.
What is this Can 1 for?
Can 1 for Lordship, the only this is the expressly hearing Lordship, so there is not. So point of and second fold of submission before your Lordship that the learned tribunal did not adhere the law as settled by the judgment of the Honorable Apex Court. The Punashati did not consider the future prospect at all in respect of the age of the deceased. And Lordship, another second third point is that Lordship, the learned tribunal awarded interest from the date of evidence that should be interest should be calculated from the date of filing of the claim application till the date of realization, but without any stipulation. But the learned tribunal one stipulation is there from the date of evidence of the PW1. That is the basic threefold submission before your Lordship. The paperwork that I have prepared, I must serve upon Mr. Roy, and matter is appearing before your Lordship.
So it is ready for hearing.
Lordship is ready for hearing.
Are you ready? Yes, so let me see. So according to you, the notional income is taken as
tribunal is 5,000. Instead of that, my claim was 15,000 per month.
No evidence adduced. How much?
There is no evidence in support of the income. There is no papers. Only the one papers they have placed before the learned tribunal, though it is not exhibited.
Okay, let me see.
But the employer has issued one income certificate that he was my employee, but employer has not come. That was not exhibited. Only the averments of the claimant wife of the deceased.
What is the how much is the certificate? As per the certificate?
Certificate is the 15,000.
And regarding Brickfield, what is the minimum wages?
Regarding the big field Lordship, minimum wage is 2,000. Actually took to something August 2014.
No, thereafter 2018.
No, the accident took place 2014.
Yes, yes.
So on the
2014, yes. 2014, how much?
2014. So kind just.
If you have that circular, bring it tomorrow. Bring a copy tomorrow.
Lordship.
I'm just making it not today.
Lordship. Can you posted on the hearing Lordship? With
Under the same heading.
Same
appear under the same heading. I'm just making it not today.
Not today. At 2 p.m. Lordship.
No, usual course it will be taken up. Bring the circular and the date is on there.
Certainly, I'll complete Lordship direction.
In his memo of appeal, Malad, there is no whisper about Malad income, Malad.
No. What is the ground? Ground of appeal is on.
Taken up in respect of income, Malad.
No, on what grounds?
Interest.
Definitely, the appellant, the claimant has come means not satisfied with the quantum.
Copy to the judgment under challenge. What the ground have taken is immaterial, or the ground will come in the hearing. That is the material. That is the first appeal. This is not the second appeal. The question always has to be formulated.
No, grounds are not taken. That
There,
he
so
accepted
both
that.
No. Judgment yes, no.
Number 22. Judgment he accepted.
My lord, praying for a short passover, my lord.
Okay, passover.
Twenty-three, my lord, for the appeal, my lord. My lord, there are two applications. One for my lord, condemnation of delay and another for stay, my lord. First, my lord, can you take up Can 2 of 2025?
Yes.
Can 2 of 2025, that is the application for condemnation of delay. My lord, appeal, my lord, judgment was passed. Judgment was passed on 31st March 2023, and the instant appeal was filed
You have
on.
deposited the statutory amount.
Yes, my lord, I have deposited statutory amount.
Yes.
My lord, judgment was passed on, my lord, 31st March 2023, and the instant appeal was filed, my lord, on.
Yes. What is the, let me see your application.
My lord, that is Can 2 of 2025. I have stated the grounds, my lord. Can 2 of 2025.
এটা তো appeal. But can take.
So this is the copy of my application, my lord. My lord, the grounds of delay, my lord, that is, my lord, judgment was passed, my lord, on 31st March 2023, and the appeal was filed, instant appeal was filed on 4th July 2023. So, my lord, annexing the.
How many days delay?
My lord, as per my calculation, my lord, there is a delay of 973 days. My lord, why this delay?
2000.
Yes, but in there 2023, my lord, appeal was filed.
Yeah, no,
Annexing.
2023, the award was passed.
Yes,
Paragraph 4.
Yes, 31st March 2023, award was passed.
Yes.
And the instant appeal was filed. Well, kindly see the memorandum of appeal on 4th July 2023. The appeal was filed, annexing the true copy of the award. Thereafter, my client has instructed the conducting advocate of the insurance company before the tribunal that to obtain certified copy. But the reason certified copy obtained in the year 2025, thereafter I filed certified copy of before the concerned department and filed this application. Otherwise, the appeal was filed in time, but
Yes,
due to certified copy.
As per direction of my senior, my lord.
Yes, record and order. Learned advocates for the parties are present. Are learned advocates. This is an application for condonation of delay filed by the appellant. The appellant in the instant application has prayed for condonation of delay of 937 days in preferring this appeal. Stop. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is furnished for condonation of the delay. Thus, the delay in filing this appeal be condoned. The application can 2 of 2025 stands allowed.
Then kindly take up kindly can 1 of 2023. That is my application for stay.
Yes, can 1 of 2023 is taken up for consideration. Yes, where is that deposit?
Yes, my lord.
No, your deposit.
Yes,
That slip.
Both.
As the can 1 of 2025.
No, 2023.
Okay, can 1 of 2023. Learned advocates for the parties at present are learned advocates in the instant appeal, as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be a stay of the judgment and award passed by the learned additional district judge, Third Court, Purbo Bardhaman, on 31st day of March 2023 in MSC case number 67 of 2014 for a period of 5 weeks from date. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest from the date of filing till realization, excluding the statutory amount within the period of 5 weeks. In the event such deposit is made within the period of 5 weeks, the interim order of stay shall continue till the disposal of this application. Liberty to mention.
My lord, your lordship, my lord, directed this interest shall be from the date of application till date of realization.
Date of filing the case till
date of deposit.
No, till the date of deposit.
Yes, your that realization has recorded.
Till the date of deposit.
Deposit.
The entire awarded sum along with the interest from the date of filing.
Date of deposit.
Date of deposit.
Relation not. Relation to not.
No.
My lord,
Get-
therefore I'm requesting that respondent is a senior citizen. And kindly take it for hearing in a short date, my lord, in December, my lord.
I can do one thing. You see, the Lok Adalat is being fixed on December 9th. I'm keeping it in the month of January. Okay. Because unless the trial court records come, you will not be able to file the paper. The trial court's record be called for at the special messenger cost of your messenger cost.
My lord.
Respondent number 1. Stop. As this claim case can be settled through the Lok Adalat, the matter is referred to the National Lok Adalat to be held in the month of December. Let this matter appear on 6/1/2026 for report of the Lok Adalat. So if it is settled, well and good, otherwise I'll take it up.
Very
6/1.
I shall try, my lord.
কিসের গো? আপনাকে কিছু বলিনি? কাগজ তো এনে গেছো? না, stay করাবো। Order ভুল ছিল আগের order।
Number 24.
24, my lord, I am appearing on behalf of the appellant insurance company. My learned friend is appearing on behalf of the claimant's respondent.
Number 1.
I have deposited 25,000. This is the copy of the challan. I am praying
Yes,
for
রেকর্ডটা দেখি।
আমি সব দিয়ে দিচ্ছি। মিনিট দাও। ও, এখন order-টা করতে হবে। পুরো service এ order করছে।
Yes, record and order. Learned advocates for the parties are present. The application can 1 of 2025 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award dated 8th day of April 2025, passed by learned additional district judge, 3rd Court Purulia, in MSC case number 42 of 2018 for a period of 5 weeks from date. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest from the date of filing till deposit. In the event the entire deposit is made within the period of 5 weeks, the interim order shall continue till disposal of this application. The trial court's records be called for at the special messenger cost to be paid by the respondent number 1. Respondent number 1. Respondent number 1.
আচ্ছা আপনি গিয়ে আনাবেন
বিকাশ মুর্মু।
wherein my lord had recorded that we shall deposit, there my lord will kindly order less statutory deposit.
Yes, that will be entire awarded sum ওখানে আছে না, along with interest from the date of filing till date of the deposit, excluding the statutory
I'm
deposit.
grateful, my lord.
So the trial court's records to be called for at the special messenger cost to be paid by the respondent number 1, Sri Bikash Murmu. As this motor accident claim case can be settled through the Lok Adalat.
This cannot be settled.
It will come again. It cannot be taken up before January.
My lord.
Let this matter be placed before National Lok Adalat to be held in the month of December. Stop. Let this matter appear on 7/1/2026 for report of the Lok Adalat.
My lord.
My lord, the special messenger cost is should be put
By the respondent number 1.
My lord, time limit is there.
I have not meant, but do it within a reasonable period. But anyway, you take your chance before the Lok Adalat also.
Next the same.
Same.
Next matter
is also same. Similar to the last matter.
Or something has to be
Yes.
altered with regard to the
Yes.
date of the order and all
Yes.
this.
এটা first time.
রেকর্ডটা দেখি। আচ্ছা, এখানে একটা জিনিস রেকটিফাই করে দেবে না, দ্যাট ইজ ওই যে যেখানে আছে ওই আগের ডেট এন্ড দি জাজের নামটা আছে না, ওটা হলো স্টে অফ দ্য অপারেশন অফ দ্য জাজমেন্ট এন্ড আওয়ার ডেটেড, এখানে লিখবেন 31st day of July 2025, passed by learned additional district judge, fast track second court, Diamond Harbour, South 24 Parganas, in MSC case number 40 of 2022. Rest all are same.
Returnable on 7th of
Same.
My lord. Grateful, my lord.
Hmm. 26. My lord, I am for the appeal, and my lord, it is insurance company's appeal, my lord, filed within time. Statutory deposit slip. My lord.
Yes, record and order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award dated 17th September 2025, passed by learned additional district judge, fast track second court Alipur, South 24 Parganas, in MSCC case number 1248 of 2022 for a period of 5 weeks from date. Stop. The appellant insurance company is directed to take steps to deposit the entire awarded sum along with interest from the date of filing till date of deposit. Stop. In the event excluding the statutory amount, stop. In the event the entire deposit is made within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. Liberty to mention.
Grateful, my lord.
My lord, in this appeal of insurance company, the awarded sum has already been deposited. My lord, the stay has been made absolute. Lord, my learned friend has filed the paper book. My lordship will kindly fix it up for hearing. My lord.
My lord, in this matter, I am appearing on behalf of the respondent claimants number 1. I have not received any.
Respondent number 1, that is vehicle owner.
No, my lord. Respondent claimant number 1, Ria Kasmi.
Oh, you are representing other sets of claimants, and she is representing some of the claimants.
My lord, widow and parents of the deceased are the claimants. My lord, my landed friend, my lord, on the far stream, my lord, she is for the widow, and my landed friend, Mr. Roy, is for the parents, my lord.
Lordship, prior to that, I have filed one application for amendment of cost title. Very short amendment is required. This claimant.
No, according no, your clients are some of the claimants.
Parents.
Parents.
Wife.
I'm wife.
So, Lordship, I have filed an application for this short amendment. The applicant number 2, name is the father of the deceased, name is Nishit Kashundi. So it should be Nishit Chandra Kashundi. To that extent, Lordship, I have filed one application.
Yes, give me the records.
আবার হ্যাঁ দাঁড়িয়ে হ্যাঁ ঠিক ঠিক এখানে বসো
So, Lordship, that I have annexed Nishit Kumar Kashundi. Only the Kumar, the middle name had to be inserted in middle of Nishit Kashundi. Ten two. আছে মামলা ধরেছিল লিস্টে
So what is there in the claim application and in the award? According to that, you have sought the amendment.
Lordship, only Nishit Kumar, just only.
Yes, record and order. Learned advocates for the parties are present. The application Can 2 of 2025, which is filed seeking amendment of the cost title with regard to the name of appellant number 2 is taken up for consideration.
Not an appellant, it's the claimant.
Sorry, this respondent number 2 is taken up for consideration. The applicant has sought to rectify the name of respondent number 2, Nishit Kashundi, as Nishit Kumar Kashundi. Nishit Kumar Kusundi. Stop. This application, being formal, stands allowed. Let necessary rectification be carried out by the department within 2 weeks.
আমি appellant.
Yes, rectification be carried out within 2 weeks. Liberty to mention.
Lordship, kindly fix any date prior to 15, Lordship, if Lordship's diary.
I've given you liberty to mention. If I can make some time, I shall hear it before.
Kindly, my humble kindly fix up the date. Otherwise,
No, let it be corrected. Okay, let it be corrected.
After that, they will send the file to the Lordship department.
No,
Otherwise, you will take time.
after it is corrected, you just mention the matter. Okay, I am granting. That is why if it is done within few days, you mention it, I shall take it up. I've given you that liberty.
So like liberty to meet your.
Yes, liberty to mention, that liberty is given.
Correction liberty is by the department.
Yes, yes, yes. That I have given 2 weeks.
Number 28.
My lord, I am the petitioner, my lord. Appellate petition. My lord, there are 3 applications. My lord,
Second
there are
appeal, yes.
3 applications.
Can 1 is for?
Can 1 is for, my lord, section 5 application. For
Yes.
condonation of delay in
And
preparing
can
the
2?
appeal, 35 days delay.
Yes.
Grounds you have taken, my lord.
Let me see. You have been served with a copy of the application.
My lord, when is appearing? My lord, lawyer's paragraph I have stated in details, my lord. Learned advocate's mother was ill.
Second can, since I have objected, that, strongly objected, but he misrepresented before this lordship court.
No, no. What?
There is a objection.
You see, can 1 and 2 is appearing in the list.
Can 1, 2,
Only
1,
as
2 and 3.
3 years.
3 is not appearing in the list.
3 is not appearing.
Anyway, I'm taking up this can 1.
Now, my lord, questions.
Can 3? He's
Substitution.
telling.
So, my lord, can 3 in questions today?
28. Oh, acha, acha. Right. Yes, let me take up can 1 first.
আজকে তো আপনার মেন অ্যাপ্লিকেশনটা কি ক্যান 3 তো
No.
আগে তো সাবস্টিটিউশন হবে তারপরে তো
No, can 1. I'm just taking up can 1, condonation.
Condonation of
মানে কন্ডিশন
Okay, substitution application is which one?
substitution application, my lord.
Can 3. Let me take.
Can 3.
First, my lord, substitutions is need in this matter.
My lord, on the date
Yes,
of the
can
respondent number 6.
Respondent number 6 died.
Respondent number 6 died, my lord. My lord, respondent number 6 died. Not known to us. Then, my lord.
Yes, which paragraph you have stated?
My lord, if your lordship kindly see, my lord. Paragraph 2 and 3.
Paragraph 2 and 3.
2 and 3.
This second appeal was filed in which year?
My lord, this is a second appeal of 22.
2022. 2022. Okay. So after this appeal was admitted.
No admission.
Not yet admitted.
Not yet been admitted.
Okay, appeal is not yet admitted.
Both the courts.
But so you see,
3 applications is
appeal
pending.
is not yet admitted. But after you served copy of this application up to section 5, when you were intimated about the death of this respondent.
My lord, section 1 is section. First is section 5 application.
I'm taking up the substitution application
Yes.
because unless the record is corrected,
Yes,
that we cannot
my
proceed.
lord, it was
Paragraph number 2.
It was intimated, my lord, by my learned friend when the matter was taken up earlier. When the matter was taken up for hearing, when this can 1 application was taken up for hearing, at that time, my lord, it was. My lord,
Now you are
Informed within a time.
no, you are representing all the respondents. Okay, and when the application can 1 and 2 were taken up,
then
your learned friend intimated.
Yes, my lord,
before the court or by to you in writing.
No, my lord, in court, my lord.
Court. So which paragraph you have
My lord,
stated?
paragraph 2.
Paragraph 2. Yes, came up for hearing.
My lord, yes, these can 1 were listed in the list of honorable justice such and such and came up for hearing on before his lordship when the learned advocate for the respondent opposite party for the first time disclosed before this honorable court regarding the death of opposite party number 6, Usha Devi Chandak, on 31st March 2024, subsequently handed over a letter of intimation to the learned advocate of this petitioner, disclosing the name of the heirs of the deceased, together with xerox copy of cremation certificate. Thereafter, my lord,
The
refiled.
question is, so from the date of information, how much time did you take to file this application?
Now, my lord, thereafter, kindly see my lord, paragraph 3. My lord died on such and such, living beyond the earth. For then the person, the photocopy of the cremation certificate, such and such is annexed herewith and marked as annexed.
Yes, annexure A. What is the letter of the learned advocate intimating you?
Intimated 7th
7/5.
May 2024.
7/5/2024.
Yeah, ma'am.
And this is filed on 16th May 2024.
Yes.
Yes, so my lord, is within time.
Yes, record an order. Learned advocates for the
Thank
parties
you,
are
sir.
present. This application, CAN 3 of 2024 is taken up for consideration. Hard learned advocates peruse the petition filed and the materials on record. This application is filed for recording the death of respondent number 6, who died on 31/3/2024. Stop. Upon perusing the petition, it appears that the application for substitution is made within the period of limitation. Thus, this application stands allowed. Let the names of the respondent number 6 be deleted from the cause title and the names of the legal heirs as mentioned
Paragraph 3.
in paragraph 3 be inserted in its place and stayed. The department to carry out the rectification within a period of 2 weeks. So let it be carried out thereafter, you mentioned.
Then, my lord,
I think this is the procedure. After it is carried out, liberty to mention.
Substitution is need.
So substitution order is passed.
Yeah.
Let the department carry out the necessary amendments and liberty to mention.
And my lord, CAN 2.
CAN 2 is for
substitution. CAN 2, my lord, is substitution application.
No, this is CAN 3. CAN 3.
This is the CAN 3.
CAN 3 is disposed.
CAN 3, your lordship just now allowed the same.
Yes.
Disposed of.
So let the amendment be carried out by the department within 2 weeks.
And my lord, CAN 2 is also, my lord, on the date of the opposite party number 2. Sorry.
Okay, CAN 2. Let me see.
My lord, here, my lord, we have
Against objection.
filed an
He
application.
made a false statement before this.
CAN 2, yes. Respondent number 2 died when? 17/3/2023.
Yes.
Leaving behind?
My lord, respondent number 3 died on 16th March. My lord, it is wrongly stated as 17th, not it, but it will be 16th. Sauraj Devi died, and it was not intimated to us. We came to know from the another case where, my lord, also decree of eviction was passed against other tenants, and the same lawyer was conducted.
Your learned friend was representing this respondent number 2.
Respondent number.
You were representing the respondent number 2. So it was not within your knowledge that your client died.
Yes. And we came to know, my lord.
This statement is a misrepresentation.
Now, my lord, if your lordship kindly see, my lord.
Objection.
Yes, your opposition. What is your opposition? Let me see.
Yes, my opposition filed.
Opposition. This is CAN 1 opposition. Okay. Okay, CAN 2 opposition. What is your opposition? Which paragraph?
Deflated.
Paragraph 6.
Country. CAN 1. CAN 1 to be set for us also.
Substitution.
এখন 19 May 2023.
With regard to the substitution of this person in an earlier case.
Earlier.
Yes.
It is based on the
No, my lord,
petition totally and
kindly
after
see our-
default,
Just a
my lord.
So this
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 petition
respondent
cannot
number
grant.
or respondent number 2 died on 17/3/2023. It is the contention of the appellants that they came to know on 29 July 2023.
my lord, we have get the reply in details in our reply, my lord, at paragraph 6. Page 5, my lord, we have stated.
Affidavit in reply.
Reply, my lord, we have stated in details how we came to know everything, my lord. Paragraph 6, my lord, kindly see. On second paragraph, my lord.
Bosun.
May I read, my lord?
Just a minute, let me see your
At
affidavit
page
in
4,
reply.
my lord,
Affidavit in reply টা পার করে দিন তো।
দাদা রিপ্লাইটা just একটা
Affidavit in reply টা কোথায় আছে? The affidavit in opposition, reply by the appellant. Reply by the appellant. না না এফিডেভিট অফ সার্ভিস তো এটা এফিডেভিট অফ সার্ভিস এফিডেভিট রিপ্লাইটা নেই have you filed your reply in court
yes my lord
কবে ফাইল করেছিল
it's not in the record
reply is made, I think.
দেখো অ্যাফার্মেশন রেটটা দেখো It was affirmed on 26th
my lord, 26th April it was affirmed.
but it is not in the record whether it is filed
Yes.
Filed or not?
ফাইল তো করা হয়েছে
File for yes.
কপি তো দেওয়া হয়েছিল নাকি এই তো টুয়ের ক্যানের কপি দেওয়া হয়েছে
order আছে recording affidavit of reply file
My lord,
হ্যাঁ
my lord,
No,
it has been served. My lord, is saying, my lord, it has not.
when
been.
filed it should be recorded in the order
26th April. It was affirmed on 26th April 2024.
that you have filed this affidavit in reply when
অর্ডারটা হয়েছিল অর্ডারটা এখানে আছে অর্ডারটা দেখো
My lord, kindly give it.
এই যে ক্যান 2
Can 1, this is can 1.
না ক্যান 2 আছে
No, it has a can 1 এ দিচ্ছে এই যে coordinate time.
এটা কি
But can 2. I'm going to the
Other
another
activities are found.
Okay, can 2. এই যে yes, my lord.
23rd
My lord, 23rd April 2024, my lord.
April
Learned Council represent appellant seeks an accommodation for further 1 week to file affidavit in reply. This is the order.
so it is filed recorded in
And my lord, thereafter it was served, my lord. The copy.
Yes, sir. Sir, that copy.
no which order that is 23/4
Huh?
no 23/4 there was an order the learned council representing the appellant seeks an accommodation for
Yes.
further 1 week time to file affidavit in reply
Yes. Thereafter, my lord, it was filed
Not filed.
and the copy was served.
no which date
on a file
Okay.
because you see that the order does not reflect filing of affidavit in reply
I know you just search করেছে.
no because you see the order sheet does not reflect that you have filed affidavit in reply
Not filed.
আমাদের এটা, my lord, this copy was affirmed.
সাবমিট করতে হবে তো আপনাকে কোর্টে সাবমিট করেন রিসিভ করিয়েছেন সাবমিট করে দিয়ে রেখে
হুম।
দিয়েছেন
my lord, in that case, my lord,
টাইম চেয়েছিলেন তারপরে আপনারা করেন
correct.
তাহলে একটা সপ্তাহ এই সপ্তাহ টাইম দিন
My
let me
lord,
find out
kindly, in that case, my lord, your lordship kindly give 1 week's time. Or otherwise, my lord, we may hand over to your lordship the copy.
Yes, give the copy.
Yes. My lord, this is the copy, your lordship. This is our reply.
না এটা রিপ্লাই
আছে
How have you explained yourself with regard to the contention of the affidavit in opposition? Yes, page 8.
My lord,
Page.
Page 4, my lord, page 4, my lord, from first, second, third paragraph, my lord. May I read, my lord?
Just a minute. Page 4. No, page 4. Page 7. No. Third paragraph is paragraph 8.
না কোনটা রিপ্লাই
No, no. Then, my, oh, sorry, my lord, I made a mistake. My lord. This is the petition.
Yes, paragraph. Page 4.
Yes.
Page 4, paragraph.
Yes. Page 4.
Yes.
My lord, if your lordship kindly see, first, second, third, from fourth paragraph, my lord. May I read, my lord? With regard to the knowledge, with regard to the knowledge about the date of death of the respondent number 2, these deponents specifically states that no copy of the substitution application on the date of the said respondent number 2, which has been annexed in the said affidavit as annexure R1, has been served of this appellant, and the appellant for the first time came to know the date of death of the respondent number 2 only on 27th July 2023 from their learned advocate in the court below, as the self-same advocate also representing and or defending in another ejectment suit filed by the respondent herein above, being ejectment suit number such and such, before the learned second judge small cause court at Calcutta on behalf of the defendants in that suit. The said suit was decreed in favor of the respondents, and the respondents thereafter filed an execution case, being execution case number 170 of 2018 in the court below for executing the degree of the suit, and in the said execution case, respondents herein filed an application for substitution on the date of the respondent number 2 herein above, on serving a copy of the same to his learned advocate, as the self-same advocate is representing the defendants of the suit. The learned advocate of this appellant in the court below, on receiving the same, informed the appellant's petitioner herein above regarding the date of death of the respondent number 2 herein above, and hand over a copy of the substitution application filed by the respondent in connection with the execution case number such and such unto this petitioner, with an instruction to file a substitution application on the date of the respondent number 2 in the present second appeal. Accordingly, appellants herein above filed the present application, being CAT 2 of 2023, annexing the copy of the said substitution application, being annexure A of the said application, which was filed by the respondent in his case number 170 of 2018, arising out of ejectment suit number such and such, small cause court, Calcutta, before this honorable court, in support of their contention regarding their knowledge about the date of the death of the respondent. Well, we have stated in details, madam. We have stated in details, madam.
He annexed the documents for another case connection, not this case connection.
Yes.
He also served
That same lawyer who
court
conducted the case, and
Copy of the document was not served upon you. The substitution
served upon.
application.
Yes.
I served the court below, learned advocate of the court below. Execution court.
But the parties have stated they did not receive copy of this application.
We have stated in details, my lord. Your lord.
Yes, record an order. এটা অ্যাপ্লিকেশনটা কোথায়? Yes, learned advocates for the parties are present. Are learned advocates.
Only
This application is CAN 2 of 2023, is filed for recording the death of respondent number 2, Srimati Saroj Devi Chandak. The application, the appellant in his application has stated that the respondent number 2 died on 17th March 2023, but the information was obtained by the appellants on 29th July 2023. Such contention is objected by the respondents on the ground that a copy of this application for substitution in an earlier case was served upon the appellant. Upon perusing the affidavit in opposition and the affidavit in reply filed by the parties, it appears that the appellants have sufficient grounds to file this application for substitution after the period of limitation. Thus, this application for substitution stands allowed after condoning the delay,
and also
the abatement, if any, is set aside. Let the name of the respondent number 2 be deleted from the cause title, and the names of the legal heirs of the respondent number 2 as specified in which paragraph you have specified? Paragraph 2.
As specified in paragraph 2.
Paragraph 2 of this application Can 2 of 2023 be substituted in her place and state the department to carry out the amendment within a period of 2 weeks, liberty to mention.
So, Mala, 2 applications allowed.
Yes,
one
two
is
weeks, one has to be disposed of.
Yes, let that be carried out. Then, my
yes, thereafter you mention after the carried out, after the amendment is carried out.
My lord, may I give a Xerox copy of our petition, my lord?
Yes, give a copy.
Then, my lord, in course of this day, my lord, because of,
let a copy of this affidavit in reply filed be kept with the record.
Kept with the record.
Copy of the affidavit in reply filed be kept with the record.
We'll give a Xerox copy, my lord.
Yes, you take and give a Xerox copy.
এক্ষুনি দিয়ে যাচ্ছি আরেকটা আছে
I'm appearing on behalf of the respondent in short.
Yeah, we are for the appellant, my lord.
So the matter is ready for hearing.
Yes,
Yes, my lord had granted us leave to file our written notes.
My just I forget my this copy. I just
So are you submitting your written notes?
Yes, I am ready to submitting my written notes. Written notes to work. Yes.
Okay, then come at 2 p.m. Both of you submit at 2 p.m. ঠিক আছে, তো ফাইল করলেই হয়ে যাবে।
I'm appealing for respondent number 1 in this matter. Your Lordship, it's a respondent appeal wherein the can which is appearing today has already been disposed of previously. Today, my learned friend is filing the paper book, so the matter is now ready for hearing.
Okay, the matter is ready for hearing.
Yeah, the can 1 has already been disposed of on previous occasion, if I'm not wrong, Your Lordship.
Yes, my lord. Disposition on 13/1/2023.
Still appearing today in the list.
Learned advocates for the parties are present. It is submitted by the learned advocates that this appeal is ready for hearing and paper books
It's being filed.
Filed today, my lord.
appeal is ready for hearing, as the paper books are ready and being filed in court. Let the paper books filed in court be kept with the record, as this matter relates to motor accident claims and there is a chance of settlement. The matter is referred to the National Lok Adalat to be held in the month of December. Parties to appear before the National Lok Adalat. Let this matter appear on 7/1/2026 for report of the National Lok Adalat and further orders.
Careful, my lord.
কাগজ দাও না দিয়েছো তোমারটা দিয়েছো তোমারটা দিয়েছো দিয়ে দিয়েছো নামটা
Number 29.
29, my lord. I'm the petitioner, my lord, appellant petitioner before your lordship.
Other side is not here.
My lord, I have served the copy. This is my affidavit of service, my lord. My lord, my affidavit of service. My lord, against the judgment of affirmance, my lord.
This is what section 5 application.
Yes. Section 5 application, my lord.
Application, you see,
My lord,
the opposite party has entered appearance.
28 days delay.
No, opposite party has entered appearance.
Opposite party has not, I don't know, my lord, whether any appearance is not. Opposite party has not yet appeared, my lord, because it has not yet been admitted.
No, section 5 we have to move upon service of the copy.
Yes, my lord, this is my affidavit of service is there.
Have you served the other side advocate in the lower court?
Directly to parties, my lord.
Not to the advocate, lower court advocate.
Lower court advocate. We have served the copy to the parties, my lord. Number 28 days delay.
Okay, let me see the application.
And grounds of delay, my lord.
Which paragraph?
My lord, grounds of delay, my lord, if you lord kindly see, my lord, paragraph
3.
Yes.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondent in spite of service of notice. Stop. Let the affidavit of service be filed. Let affidavit of service filed in court be kept with the record. The application for condonation of delay is taken up for consideration. Upon perusing the grounds and upon hearing the learned advocate, this court is of the view that delay of 28 days in preferring this appeal should be condoned. Thus, I condone the delay in preferring this appeal. This application for condonation of delay can 1 of 2025 stands allowed and disposed.
Okay.
My lord, 30, I am for the appellant, my lord. Kindly take the can 2 first, my lord. Can 2 is my extension application for injunction order, which was passed by the Honorable Division Bench at page 11 of my application.
This is the second appeal. Appeal has already been admitted. Formal stay is there for extension. They have liberty.
Today, the injunction order is expiring today, my lord. I have served the.
You are representing all the respondents.
There are 2 respondents. I am referring both.
Yes, give me the
Can
copy
2.
of the application.
Can 2. এটা extension আছে. Can 2.
I cannot have any objection regarding can 2 because there are division bench order which appeal has already been admitted. Appeal to be heard after filing of the papers.
My lord, page 11 is the order, my lord.
Yes, record an order. Learned advocates for the parties are present, are learned advocates. This is an application for extension of interim order passed by Honorable Division Bench of this court on 2/9/2025. Upon hearing the learned advocates and considering the facts of the case, the interim order of injunction stands extended till disposal of this appeal.
Grateful, Lordship.
So the
Paper book has to
the appellant is granted liberty to file the paper books on or before.
My lord, the LCR has to come. We have deposited the cost, so LCR has to come. Then informal paper book will be.
The appellants, upon arrival of the trial court records, shall take steps to file the paper books. Let this matter appear on 5/1/2026 under the heading to be mentioned.
Grateful, Lordship.
Maharaj, sir, I'm praying leave to file my Bhokaladama. Bhokaladama come to me,
Yeah.
but there is some defect.
The learned advocate for the respondents is granted liberty to file the Bhokalatnama in course of the day.
No, Maharaj, so next week, because they are the village.
Okay, within 1 week.
Grateful, Lordship.
ইয়েটা করে দিন শুধু এই জাস্ট 32টা লাস্ট 31টা বাকি আছে তো 31টা লাস্ট আইটেম
Number 31.
Your Lordship, I'm appearing behalf of applicant, Your Lordship. I'm led by Mr. Sunny Nandi, my lord. His cousin brother is getting married within 2 days, my lord. And the ceremony.
make it not this week.
Yes, Lordship, kindly take it this matter next Tuesday, my lord. Can it be?
Yes, record an order
I'm grateful. I'm appearing on behalf of the respondent.
on the prayer of the learned advocate for the appellant. The matter stands adjourned till 3/12/2025.
I'm grateful to your Lordship.
Respondent number 2 tomorrow.
A 2 PM fixed matter আছে
Item 32, my lord.
after recess.
My lord, I am praying for adjournment, my lord. So,
Lordship, I have already served. Mr. Shohidur Rahman is for there is a
Okay,
stay.
I'm making it not today.
Lordship, stay order is pending, Lordship.
my lord, I am for the respondent number 2. Respondent number 1 has to appear. I'm the owner of the vehicle.
No,
I
I'm
have
just
gathered
making it not today. Come tomorrow.
Grateful, my lord.
Matter item number 10.
Lord will kindly pardon me.
My lord,
So
here.
today is fixed for filing the written note.
Written notes of argument. I am submitting the written notes of argument and also the service.
This is my written notes.
Yes.
Your lordship, here.
Yes.
The previous occasion already has been settled that the disease was the driver and has established by the evidence of document, that is driving license, that exhibit 10, my lord. But now, your lordship, the question has been raised that the exact number of working days of the deceased has not been established because the evidence or other documents. My lord, here, but your lordship, as per the West Bengal government minimum wages circulated, that is in the year of the 2017, because the accident date was in the year of the 2016. My lord, this is the minimum wages.
So have you disclosed it in your written note?
Yes, already disclosed it. My lord, here one
thing. Give a copy of that.
Yeah, certainly.
Thank you.
The incident took place in which month? Which year?
October 2016.
And the notification?
2017 January. Okay. Because the previous year, in the year of 2016.
What is the minimum wages of drivers?
Right. Minimum wages of driver. Yes.
And this was an auto driver.
This is for January to June.
How much is there?
The skilled is the Zone A 9131 and Zone B 8069 monthly income. Here, if your lordship kind to the D part, to arrive at daily rates, monthly rates shall have to be divided by 26 and to be rounded of the nearest rupee, and to arrive at weekly rates. Daily rates shall have to be multiplied by 6. That is the circulation of the West Bengal government, the minimum wages act.
That is driver.
That is driver, yes, my lord. Skilled
skilled and semi-skilled.
Skilled and semi-skilled, my lord. Right. My lord, here.
How much is the trial court?
Trial court only the notional 3,000 per month.
3,000.
Sorry, 3,000, not 3,000.
No, probably 9,000.
Notional income 15,000.
Probably 9,000 or something.
3,000 per month.
3,000 per month. No, 15,000 notional income.
Tribunal assessed.
Another matter.
Another matter. In this case, tribunal assessed 3,000 per month.
No, whose appeal is this?
His appeal.
My appeal.
Claimant's appeal for
Yes.
enhancement.
No, my lord, one thing. My lord, the learned tribunal taken only the notional income. That is the appellant submit as per the evidence as well as the claimant application, the 3,000 per day. So the 9,000 per month. But
300 per day?
300 per day. And tribunal assess only the notional income, that is.
That is 3,000 per month.
That is 3,000 per month.
What I am submitting.
Yes. My lord, here the
anyway, that was the dispute.
That was
with regard to the income for which you have come.
Yes, my lord.
With regard to that dispute, according to you, 2017, the minimum wages is
9,000.
Semi-skilled.
Semi-skilled.
Auto driver is semi-skilled, not
auto driver is semi-skilled, my lord.
That is 8,000.
No, 8,000, not
how
8,000.
much is
there? Skilled is 9,000. 9,000 skilled. Zone B is the 9,131.
Okay. If you have any notification, if you have any notification that is prior to 2017, you may file it on the next day. Anyway, I am concluding the hearing.
My lord, yes, because this is not applicable in this case
This
because
is 2017.
January to June. So the prior.
If you have it,
I'll bring it.
My lord, 2016, as per the when the as per the internet shuffle to the internet, through internet, I have seen that not downloaded. In the year of 2016, the skilled and unskilled, the semi-skilled.
If I have it, I'll get a copy. If in case I can find it, I'll get a
Only in the year of 2017, now 2025, all the downloaded has been done.
Yes, record and order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. CAV. let the written notes of arguments filed be kept with the record. Keep that, you have given that notification also?
Yes, yes. Grateful, my lord.
Grateful.
Yes, my lord, I am for the respondent claimants. I have filed a cross appeal. My lord, kindly recapitulate, my lord, this thing. My lord, here the
Day is fixed for what? Filing written notes?
only, my lord, I have handed over the, my lord, the
Oh, regarding that leather matter.
Yes.
leather na, my lord.
Latte workshop.
Lede.
Latte workshop.
My lord, your lordship kindly sees my notification which was handed over to me yesterday.
Yes.
Which you handed. Your lordship kindly got it.
Yes.
The circular. Here the accident took place, my lord, 5th January 2023. My lord, which I have given the circular, that is 1st January 2023 to 30th January 2023. Your lordship is seeing the notification, circular.
Yes. This,
No, this is not. This is.
no, this is with regard to, you see, with
My lord,
these matters, regard to this, does not
Let
regard to
he-
this clinical establishment.
No,
Where
no,
is this? Where
your
is-
lordship, yes,
you see, the victim used to work in a
lead machine shop.
lead machine shop.
Lead machine shop and মানে industry or মানে factory. মানে here, your lordship kindly see, turn to page. Your lordship kindly turn to page 26, column number 26.
Column number 26. Okay, this. Yesterday you pointed to column number 10.
Column number 19. That was wrongly, my lord. It is kindly.
Okay.
26. Your lordship kindly see skill. Skill portion, turner, fitter, electrician, molder, firearm, and lead man. Your lordship got it?
Yes.
Lead man. So this notification, my lord, first part is, my lord, Zone A. Now, my lord, if your lordship, my lord, your lordship probably, my lord, is aware the circular Zone B and Zone A. Zone A is confined to the, my lord, the municipality area, and Zone B is other than the municipality area, the panchayat area and others. This is the, my lord, the circular.
This is what with regard to? Yes, who is appearing?
B. Your lordship kindly see B and B. Implementing areas. Zone A. Areas under
This
municipal.
circular is for shops and establishments.
Yes. It is also issued by the, my lord, the Labour Commission.
In shops.
Yes. Here, manner A, B. Manner is small letter B. Implementing areas. Zone A. Areas under municipal corporation,
Just a minute.
municipality.
Page.
First page.
Yes.
Zone A, Zone B. Zone A is confined only to municipal area, and Zone B is other than municipal area. My clients, resides or the disease resides in other than the municipal area. So Zone B will be applicable. So here, column number 26, Zone B is
26.
26.
Yes.
Regarding skill lead machine factory were confined to 10,517. I am restricted to 9,000 since my claim is about 9,000, and the disease wife says my husband used to earn rupees 9,000 per month. That was reflected in the deposition on the claim application. My lord, kindly see my lord,
The deposition also was 9,000.
9,000, and also claim application it was stated 9,000. So my lord, I'm restricted to 9,000. On the basis of 9,000, my lord, I made calculation. I will hand over my lord, the assessment. My lord, here it says, my lord, Zone B is second part, 10,517. And
Let us see once again the deposition. What is
Yes.
the nature of the work the victim is to do?
My lord,
Okay, latte shop means what? What is the nature of the work?
late shop, my lord, latte shop. PW1, page 6 to 11.
Page 6 to 11. Okay, 11.
That is the deposition of the Pinky Gorai.
PW1.
She is the wife
Yes,
of
that
the
is
deceased.
there. Now regarding, you see,
My lord, paragraph 5.
paragraph 5.
That my husband was a. Yes, my lord, also paragraph 4. That my husband expired due to motor vehicle accident, and at the time he was aged about 31. My husband worked at lead workshop, engineering works, namely Arjun Ghosh lead workshop proprietor Arjun Ghosh, situated at Taltor Mall near Bakuria petrol pump, adjacent to Saithia Barampur Road, PS Saithia, District Birbhum, and he earned rupees 9,000 per month. Paragraph 4. And
In cross-examination, what did he state?
cross-examination, manner there is the documentary evidence regarding. Cross-examination part is page 9.
Yes.
Page 10. Page 9 says the documents which the wife of the deceased filed, the cross-examination. May I permitted to read? I am well aware about the pleadings of the party so and so. My husband studied up to class 9. My husband so and so, so and so, so and so. I cannot file document how long my husband worked in the shade workshop prior to his death. I cannot file any document in respect of remuneration of 9,000 per month. My husband, which he used to draw the shade workshop. I cannot produce any bank account in respect of salary of master. I cannot say the distance between our house and place of work of husband. This is, my lord, that reflects that no documents, my lord, I could file.
So I cannot document respect of remuneration.
Remuneration. But it was, my lord, not, my lord, suggestion that he was not working as a, my lord, in a lead factory or lead, my lord, the engineering
So the
shop.
question is, if you accept this, my husband had no special degree for performing engineering work in workshop. That means you have to come to this category, either unskilled or semi-skilled.
Yes.
So if you come under this category of unskilled, how much is there?
Unskilled is, my lord, 8,000. If you
No, question is how much is there, you see?
my lord,
No,
column number 26.
Column number 26. But unskilled means, you see,
My lord, lathe, my lord, here it was not mentioned. Lathe only mentioned in skilled. So naturally, a person who, my lord, used to operate lathe machine, he was a skilled person.
no, his nature of work, his service which he used to discharge, what under what category he was, under what post he was working, the nature of work he used to discharge, that is not neither in chief nor in cross-examination.
Yes.
Only he used to work in that particular workshop. But what was his nature of work, that is not there. So even if it is considered to be unskilled, so is it, how much it comes? 8693.
8693. But near about 9,000.
And unskilled, okay. We have to go through zone B.
Zone B. And my lord, Zone B skilled.
Moment you say this latte man, that means he has to be skilled.
He
Unskilled person cannot be recruited. So
Yes.
you have to bring him under unskilled person, some other work, not mechanical work.
Mechanical work, but my lord, since my lord,
And it is 8693 or maximum 9000.
9,000. On the basis of 9,000, I leave it to your lordship. My lord may calculate and my lord assess the compensation and pass an hour. 9,000. Now, my lord, in my cross appeal, this is the one ground I have taken, that the learned tribunal has arbitrarily assessed 5,000 instead of 9,000.
Okay, this is your ground of appeal. And what is your ground of appeal?
No, my lord, another ground is, yes, their ground is twofold. One is the parental consortium and my filial consortium and my spouse consortium given to all of them.
How much is awarded on ground of
1,60,000
total?
Total. 40,000 into 4. My lord,
and this is a married person.
This is a married person. Your lordship, my lord, I have handed over the notes of argument where my lord, I am relying the filial and consortium.
Because you see, Nanu Chand confined to unmarried children.
Mala.
Nanu Chand.
Nanuram.
Nanuram.
Nanuram, thereafter, my lord, several judgments, my lord. Here also, my lord, I have given the 5 judgment of the Honorable Supreme Court, even after passing the, my lord, the award of Pronoy Shetty. Pronoy Shetty does not say the consortium only confined to the consortium to the wife. The other person also entitled to get. My lord, kindly think over if my lord parents, my lord lost his child. My lord, they are not entitled to my lord parental consortium.
It's also clarified with regard to Nanuram. But Nanuram confined.
Nanuram.
Chand.
Nanuram also discussed the, my lord, the parental consortium.
Only parental, not others.
Yes, others.
That was the facts of the case.
But here, the disease, my lord, the disease have a 4 banded dependent, 4 banded the.
See, at best it can be, you see, that maximum limit of pronunciative 1 lakh or 80,000 as it may be. And if a court thinks that, yes, consortium should be granted to all, 1, 2, 3, 4, then let that be distributed instead of 40,000.
Your lordship has
that 10,000, 10,000.
My lord, your lordship has power by virtue of Article 141. Because
how 141 is vested with the High Court?
High Court. So your lordship is being a judge of a High Court, my lord, can give compensation because the Supreme Court.
You should try to limit that. Okay, pronunciation is maximum 1 lakh. Whatever is to be given, if I think that yes, all should get, then let me distribute all. That 1 lakh amongst all. If there are 10 children.
Shetty, my lord has never narrated, my lord, the factual aspect.
Limitation. Consortium, okay.
Consortium
up to 80,000 maximum.
70,000, 15,000, 15,000, and my lord 40,000. And my lord Purnashetty also says that every 10 years 10%. It should be increased 10%. That is 77,000, 84,000. But my lord, the Purnashetty does not say that if there are my lord, other claimants, my lord, like my lord, the brother, sister, husband, the father, or the my lord, sister, or the my lord, the children, my lord. So they are not entitled to my lord, get the consortium. That was given, my lord, in my judgment. 5 judgment I am relying. Your lordship kindly see in my notes of argument. Notes of argument একটু দিন না। ওই এইটা না, এটা সঙ্গে সঙ্গে এই কম্পাইলেশন। My lord, your lordship kindly turn to page 79 onwards. My lord, the first page your lordship kindly see. First page of my notes of argument.
Yes.
Magma General Insurance Company
Yes,
Limited.
yes, this is the reported judgment.
Reported, Nanuram.
Yes, yes.
Now, my lord, second judgment is the Harpit cow, where my lord, disease have a, my lord, the children and mother of the disease are entitled to 40,000 each. That was also Supreme Court decided in 2022.
This page 115.
Page 93 to 101. That is Harpit cow.
Yes.
And my lord, page 102 to 114, that was Anjali and others versus Lokendra Raut. That was, my lord, page 102 to 114. Here also the 44,000 loss of parental consortium to each 3 children. And fourth one is, my lord, the New India Assurance Company versus Simoti, Somoti and others. Decided, my lord, on 7 September 2020. That is 115 to 148. This is also the Honorable Apex Court judgment, whereas parental consortium, spousal consortium and filial consortium are given. So these, my lord, 5 judgments I am relying. Since the learned tribunal has granted, my lord, 1,60,000 as a, my lord, consortium, in support of that, I am relying the 5 judgment of the Honorable Apex Court. This is my submission. And my lord, my learned friends, my lord, one of the ground that the father is not dependent, but the my lord, the deduction on account of personal living expenses would be 1/3 instead of 1/4. Learned tribunal, my lord, deducted 1/4. Now, my lord, I am relying on judgments, my lord, of my written notes of argument. Kindly see.
What is your written notes?
That is also, this is also written notes.
This is only compilation.
Compilation. My lord, your lordship, kindly see. My lord, এইগুলো page deduction on personal revenues, page 64 to 68. Yes. ওই তোমার সাধনা তোমার. This is also Supreme Court judgment. Here the disease aged about, here disease aged about 24 years. Claimants are 5 members, including page 64 to 68.
Yes.
Your lordship, kindly see page 64, Sadhana Tomar and others. Father, claimants legal representatives. The father and younger sister, disease aged about 24, claimants are 5 family members, including father and younger sister. Tribunal held that father was not dependent on the income of the disease, and since father is alive, younger sister was not dependent on the disease and deducted 1/3 personal. High Court affirmed the tribunal held father and younger sister fall within the definition of legal representatives for claiming compensation under the Motor Vehicle Act. Therefore, taking dependent family members as 5 deduction towards personal living expenses would be 1/4. My lord, your lordship, kindly think over. My lord, a minor died. My lord, where the claimants are the, my lord, the father and my lord, the mother.
This is not the case of a minor or unmarried person.
Yes, my lord, here.
Different case.
Yes. My lord, this Sadhana Tomar case is, my lord, is a married person died. There are 5 claimants, including, my lord, the father and younger sister. And also the also wife and the, my lord, the sons and daughters. There are 5 numbers. Tribunal and High Court, my lord, The tribunal, my lord, consider, my lord, 1/3. High Court affirmed this judgment. But Supreme Court says, since father and younger sister will come under the definition of, my lord, 166. If your lordship have a look, my lord, 166 of the Motor Vehicle Act. The Motor Vehicle Act,
নিয়েছি
the manner in our case, the learned tribunal discussed 166. This is a case under section 160.
Yes.
Section 160, an application for compensation arising out of an accident of the nature specified in subsection 1 may be made by the person who sustained the injury, by the owner of the property where death has resulted from the, by all or any of the legal representatives. So, my lord, here fathers and my lord is also a legal representative, not legal here. If your lordship sees section 164, that was only confined to, my lord, legal year. And, my lord, under the Motor Vehicle Act, there is no, my lord, iota, my lord, narrated in the Motor Vehicle Act, only my lord, the personal law, that is Hindu Succession Act, in case of a Muslim, my lord, Muslim personal law will apply. If, my lord, the claimants are, my lord, the legal representative, they are entitled to file claim application and they are also entitled to get compensation. Now, my lord, on the basis of my lord, I have calculated on the basis of 9,000. My lord, if your lordship kindly see my assessment, 9,000 annual income, 9,012, 1,08,000 future prospect that the learned tribunal consider 40%, that comes 43,200, adding 108 plus 43,000 comes to 1,51,000. Now, my lord, 1/4 deductions, it comes, my lord, 1,13,400 after deduction. So multiply 16, since the disease was aged about 30 years, as per Sarla Bharma and Punai Shetty, the multiplier would be, my lord, 16. So 16 tribunal used, I am not disputed. 16 also, my lord, assessed in my assessment list. A multiplier as per age of 16, it comes 18,14,000. Now, my lord, funeral expenses, loss of estate, tribunal granted 15,000, 15,000. Since the accident took place 2021, and my lord, Punai Shetty passed the judgment in November 2017. So, up 10 years passed. So, they are entitled to, my lord, 10%. So, my lord, 30,000 into 10, my lord, that is, my lord, 20%, that is 36,000. 30,000 plus 3,000, 36,000. And loss of constitution, 1,60,000. It comes, my lord, total 20,10,400. And 6% interest from the date of file. My lord, this is my submission.
Yes.
Your Lordship, my reply will restrict only to threefold arguments which have been put forth.
Your challenge is on the quantum of income.
Quantum of that's their challenge. They have
You have challenged it.
my two challenges are in respect to the consortium shouldn't be more than of 40,000, which the learned trial court has given 1,60,000. And my second limb of argument is on the point of whether the father should be considered as a dependent and whether on the point of dependency, the deduction should be at 1/3 or 1/4, Your Lordship. So now replying to the first question of the point of income, Your Lordship, which in the cross appeal, they have taken the point of whether the income of the deceased should be considered as 5,000 or to the extent of 9,000, Your Lordship. Now, Your Lordship, firstly,
Your Lordship, my Lord has already showed Your Lordship the deposition. I again once again wants to submit that page 9. Your Lordship will find that in the deposition it has been stated that they have stated that the income this is 9,000. Now, during the cross examination, it has been categorically stated that I am well aware of the pleadings of the parties as well as my affidavit in chief, and thereafter I signed the affidavit and my affidavit in chief. I passed the secondary examination. My husband studied up to class 9. This is also very important to note, Your Lordship, that they are claiming to they are claiming to handle a machine.
That is why I pointed out whether it is totally unskilled.
Yes,
or
Your Lordship.
it cannot be skilled, either unskilled or semi-skilled.
Lordship, that I will submit. Whether how it is not applicable, I will show you, Lordship. Now, my husband has no special degree of performing engineering work in workshop. I shall not file any letter to prove that my husband was the worker in the lathe workshop of proprietor Arjun Ghosh. I cannot file documents how long my husband worked in the said workshop prior to his death. I cannot file any document in respect of remuneration of 9,000 per month of my husband, which he used to draw from the said workshop. I cannot produce any bank document in respect to salary of my husband. I cannot say the distance between our house and the place of work of my husband, but 30 minutes time is taken to go there by vehicle. Incident took place at so and so. Now, Your Lordship, the most interesting part is the claimant couldn't submit a single scrap of paper, or couldn't at least produce couldn't adduce evidence by Mr. Arjun Ghosh to show that he was working there. So there is nothing in record today before this honorable court to prove that the person is working in a lathe shop. Suppose tomorrow a person who is sitting idle in a house died in a road accident, and his wife come up before this court or before the learned trial court below and say, my husband was an advocate of a court, so and so court. So he has to prove it at the end of the day, and court cannot.
It is easy to prove that a person is advocate, but it is difficult to prove.
Suppose he's working,
that a person is working
suppose
in an
he's working in
unorganized
so and so
place.
firm. So suppose I have engineering.
Yes, it is very difficult to obtain documents with regard to unorganized sectors. Okay, or save and accept oral evidence unless the employer is of so sympathetic to come and depose.
So at least a summon could they could have tried to issue a summon against the Mr.
The question is, you see, whether how far it is to be believed.
At least a person who is getting of 9,000 rupees, there should be some reflection in the bank account, Your Lordship. That should be there. I am accepting.
To survive a family, some income is required. That has to be
9,000 who is income.
whether 9,000 is a very exorbitant amount or it's a
per month. If someone is earning 9,000, suppose he is expending 9,000, something should be in the account. Something
in order to run a family, income is there, must be there.
Okay, but a benefit of doubt should also be given to the insurance company as well today, because at least a single scrap of paper should be there. Single.
Very difficult in unorganized sectors. That is why this skilled is not applicable. At best, if because this person does not have any degree and something, so it is difficult to infer that is a skill. At best, he can be unskilled person can work.
Now, I think Your Lordship is well aware of a principle of estoppel, Your Lordship. I think Your Lordship is well aware of principle estoppel says when somebody submits before the court below a certain point, they cannot distract that in a higher court, in any higher court.
Whatever is submit, let us go by the evidence, whether the court
I am
should
coming
believe it or not.
kindly page 18 of the judgment, Your Lordship. Then kindly come to the page 18. Issue number 3 and 7.
Page 18.
Running page 18 of the paper book, Your Lordship.
Yes.
Issue 3 and 7, Your Lordship.
Yes.
For the sake of brevity and convenience, all the aforesaid issues are taken up together for consideration and discussion. Learned advocate for the petitioner filed written arguments stated the fact of incident, elaborated analysis, the evidence adduced by the PW1, PW2, and also calculated the expected amount of compensation. Besides that, he made oral argument and submitted that there are 4 numbers of petitioners in claim case, and he prayed for consideration of notional income of the victim as 6,000 per month. It's their submission, Your Lordship. It's not ours. And we have submitted to that extent. The learned advocate of OP Insurance Company submitted for consideration notional income to the extent of 5,000 per month. Now, our submissions of 5,000 per month has got a basis because Your Lordship is well aware that the prevalent notional income which is followed by this Honorable High Court is of 5,000 per 5,000, which has not yet been.
There is no such mention.
Yes, Lordship. But this
case.
Yes, Your Lordship. I bow down. I bow down. But the practice which is followed by this Honorable Court is of 5,000 per month in case of notional income, where there is no scrap of papers is being given. So this notional income has been derived only to the extent, Your Lordship,
If there are Supreme Court judgments
Yes,
with
Lordship,
regard to notional income, that also has to be considered.
Yes, Your Lordship. That Your Lordship will consider. I cannot.
That is why Pranay Shetty is the authority. So whether there is any mention with regard to that notional income.
No, then Pranay Shetty, the minimum wages thing comes up, Your Lordship. But here,
no, where their minimum wages apply, it is minimum wages.
Yes.
In some profession or unorganized sector where it could not be derived, then what should be the notional income?
But here the claimant has not proved that whether he's a lathe worker.
Very difficult to prove.
I understand, but some benefit should also be given. Then
you see, for these helpless person, it is very difficult to come and
for that. Why, if someone is sitting idle,
now the question is, you see, to run a family, income is necessary.
Yes, so that's why the 5,000 is.
Oh, 5,000 is sufficient. Whether or some more income was earned.
Your Lordship, that if Your Lordship could take into account, Your Lordship, they have themselves claimed 6,000 per month.
But no, that is the submission, definitely.
They have submission.
If they cannot prove, they have to make some submission.
They have said that they are willing to take 6,000 per month as notional income. So, my submission today is
submissions can be made, but court has to come and see whether first of all it is believable or not, and what is the just and reasonable.
Yes, Your Lordship. Yes, Your Lordship. So now there is a 5,000 per month. 5,000 per month is there is our submission. 6,000 per month is has come up from the petitioner's side before the under lower court below.
Anyway, now the petitioners are aggrieved by that income assessment, and they have come.
So it could. My submission is that following the principal estoppel, it couldn't exceed much more than 6,000 today, because they have submitted by themselves that they want 66,000 to be their per month income, to be considered as per month income. So this is my first limb of submission, Your Lordship, to their submission in respect to increasing the income point, Your Lordship. And also they have used a circular of showing that why the skilled, unskilled to be used in this case. Now the first submission to this is this circular has not been they have not taken help of this circular before the learned trial court below. This is the first limb of submission. If they have done so, we could have taken a counter to that. They have not done so.
Now you submit whatever you want to submit.
Because
now it is before you.
My submission to that is this circular is not admissible for them at all, because they couldn't prove before the learned lower court below that he is working as a lathe worker. There's nothing in record today.
Question is, okay, this lathe worker he has submitted.
Yes.
Now whether it is up to the court to accept it or not.
Yes.
Now the question is, that is an unorganized sector.
Yes.
So regarding lathe worker, if there is any circular, then that has to be taken into
kindly come to the first limb of the circular. The minimum rates of wage for the employees employed in the following 31 scheduled employments. Today, my submission is he is not within the 31 employed sum. He may come today and say he is a lathe worker or something. I am challenging. I am saying that he is not a lathe worker, and so this circular will not be applicable to him. He may be working something. He may be working for the livelihood of his family, but that may be beyond this scheduled employment. That may be the 31 scheduled employment which has been put forth in this. Maybe he's working beyond that, and to get the benefit, he has said that he is a lathe worker to take the benefit of this circular or something like that. This is my first limb of submission in respect to the income point, Your Lordship. Now, in respect to my grounds of appeal. The first ground, my ground is the consortium part, Your Lordship. The consortium is আরে আমি তো একই জিনিস 10 বার বলবো এখন Your Lordship, there is a judgment which has been submitted before Your Lordship yesterday, FMA 3200 of 2016. তো দিন না একটা judgment দিয়েছিলাম কালকে।
You submitted?
Yes, Your Lordship.
Justice Patronak's judgment?
Yes, Your Lordship.
Yes, that is
Yes,
there, but
Mr. Singh was the amicus curiae, has been appointed in this case by the learned coordinate bench, and the learned coordinate bench has
subsequent to that, if there are other honorable apex court judgment, those cannot be
Yes, Your
ignored.
Lordship. This order has never been set aside by the Honorable Supreme Court.
Very
Till
well,
date.
subsequent. In
Subsequently,
similar
has also-
facts, if
yes,
the
Your Lordship.
Honorable
I
Supreme
will
Court has
show Your Lordship in this case, Pronoy Shetty, Nanuram, Somvati's case, Satindra Kaur's case has been discussed.
No,
I will
that was with regard to what? What consortium? Filial consortium?
total consider what could be given by the.
That is another thing. What was the facts of that case? Anyway, I shall go through that.
Yes, Your Lordship, I will to show one paragraph, just one paragraph.
Yes,
I have a
yes.
judgment thing now. I have a judgment thing.
Did you file any compilation? Or
Only
just-
one judgment I have given, Your
Okay,
Lordship,
fine.
till now. I am not that much equipped with cases. Your Lordship, kindly come to page 14, running page 14.
Yes.
Your Lordship, it is quite evident. I'm reading from the first paragraph, Your Lordship. It is quite evident from the above that the law relating to loss.
Page 14.
Page 14, running page 14 is in the below, Your Lordship.
Below.
Below, the page number is mentioned the below. Page 14 is the running pages are mentioned the below, Your Lordship.
No, this is judgment. Page 14 of the judgment.
Page 14 of the judgment, Your Lordship. Page 14 of the
Yes.
judgment. Can I read, Your Lordship? Yeah. It is quite evident from the above that the law relating to loss of consortium has been left
No, it is not telling. This is an unreported judgment.
Huh?
Unreported
বৃহস্পতি
judgment.
একবার দেখি না একবার দেখি কোন পেজটাতে গন্ডগোল হচ্ছে একবার দেখে দি নিতে গিয়ে ভুল করবো। হুম। এটা পড়ি নিতে লেখা আছে Can I read you, Lordship? It is quite evident
Right.
from the above, the law relating to loss of consortium has been left untouched, and Pronoy Shetty's case, Supra has been said to rule the field. The additional quantum on account of filial consortium, as awarded in Nanuram, is at best been allowed in exercise of authority under Article 142 of the Constitution of India in order to render complete justice in the facts and circumstances of the case. As a court of appeal under Section 173 of 1988 Act, this court does not have such power. It is clear that the amount towards loss of estate, loss of consortium, and funeral expenses has already been quantified by the Constitution bench of the Honorable Supreme Court in Pronoy Shetty's case at rupees 15,000, 40,000, and 15,000 respectively. Once the decision of the Constitutional bench of the Honorable Supreme Court is cited, it must be applied and no different view can be subscribed as it is a law laid down within the meaning of Article 141 of the Constitution of India. Accordingly, no further amount shall be granted towards loss of consortium beyond the figure provided as above by the Constitution bench. For the reasons as above, the subsequent decision in Somvati's case and Satindra Kaur's case cannot be applied, as the amount of compensation to be awarded as consortium will be governed by the principles as laid down in Pronoy Shetty's case. This is my submission, Your Lordship. So the maximum what they can get is 40,000, 15,000, 15,000, Your Lordship.
Okay, let us see this
Yes,
judgment as well as the other Supreme
Yes,
Court
Your
judge.
Lordship.
There are
Yes, Your
places like-
Lordship. I bow down. I bow down. Now, in case of the third is whether
So regarding income, regarding consortium,
done.
And the third is?
Third is regarding whether the father should be
Yes,
considered
regarding dependent.
dependency now. Your Lordship, regarding dependency, there's a Supreme Court judgment of 2022, which I will like to rely, Your Lordship. Huh? বেশিক্ষণ নেই।
Yes.
Yes, Your Lordship. এক্ষুনি ছাড়ছি। Your Lordship, kindly come to para 16, para 14 onwards. Para 14 onwards, it says that the MV Act does not define the term legal representative.
Okay, just a minute. Para 14.
14, Your Lordship. It will be the running page 15.
Yes, the MB Act.
The 14 and 15, I'm putting in a nutshell, Your Lordship. Para 14 and 15 says the MV Act is silent about a legal representative. Now, in case why the dispute is why the father couldn't be considered as a legal representative immediately in a state of accident of his son or daughter. Now, as per to the Hindu law and the Hindu Succession Act, Your Lordship, the Hindu Succession Acts.
No, this is paragraph 14. Then
14 and 15.
15.
I'm stating why the paragraph.
This is legal representative.
Legal representative has not been defined in MV Act.
So what is the observation? Ultimate observation.
Ultimate observation comes in para 16, which I will show you, Lordship. Para 16 is the ultimate observation.
Yes.
Para 16 is says, in our view, the term legal representative should be given a wider representation for the purpose of chapter 12 of the MV Act, and it should not be confined only to the mean of spouse, parent, and children of the deceased. As notified above, the MV Act is a benevolent legislation enacted for the object of providing monetary relief to the victims of the families. Therefore, the MV Act calls for a liberal and wider interpretation to severe real purpose underlying the enactment and fulfill its legislative intent. We are also of the view that in order to maintain a claim period is sufficient for the claimant to establish his loss of dependency. Section 166 of the MV Act does make it clear that every legal representative who suffers on account of the death of a person in a motor accident should have a remedy for realization of compensation. Your Lordship, then it's go on. It's a settled.
Regarding the fathers, what is observed?
It is. I will show you, Lordship. It is settled that the percentage of deduction for personal expenses cannot be governed by a rigid rule or formula of universal application. It also does not depend upon the basis of relationship of the claimant with the deceased. In the same case, the father may have his own income and thus will not be considered as dependent. Sometimes brothers and sisters will not be considered as dependent because they may have either be independent or earning or married or be dependent on the father.
Yes, that means there is no straitjacket for
Yes, Your Lordship. That's my humble
Each
submission.
case has to be decided on its own
on merit. And now in this case, the claimant couldn't prove that the father was dependent upon the deceased. This is my humble submission. So it cannot be a straitjacket formula that I have made the father as a claimant. It will not make it will not give a right to get to fall under the dependency clause. So anyone can be can be a claimant, but dependency has to be checked and governed on case-to-case basis. And in this case, there is nothing to prove that the father was dependent upon the deceased herein. And Your Lordship, just last submission, I'm restricting everything as it is as part of the Hindu Succession Act also, Your Lordship. In the Hindu Succession Act also,
there is father's right is there.
class 2. In class, yes, in class 2, Your Lordship is well aware.
That also cannot be applied here.
No, it cannot be
As
applied.
per the observation of the Supreme Court.
Yes, the straitjacket formula cannot be applied. It depends upon
Each case will be decided upon the facts.
Case to case. Nothing. I rest my case.
Yes, record an order.
One thing,
No, what one thing?
No.
You have made your submissions. Yes.
The first judgments, 19 judgments are with regard to the assessment on the basis of minimum wages notification.
So you have confined your arguments only with regard to that quantum. But notional income.
Not notional income, as per the Minimum Wages Act.
Yes.
Yes. That was reflected in manner. I've given 19 judgments. 11 judgments.
So ওই যে single bench এর judgment দিল কোথায় গেল যে
In my compilation.
এর মধ্যে আছে তো দেখে করে
I'm getting.
Yes. Yes, her learned advocates for the parties are present. Her learned advocates. Hearing is concluded. CAB. Let the written notes of arguments filed be kept with the record. Yes, call the original site.
ফালতু দাগিয়ে কি লাভ?
Original site, daily list, Pathar matter, item number 4.
My lord, mentioning, my lord, may I have your lordship's kind indulgence to mention, my lord, it is that matter that we moved an application for occupational charges for the DT. My lord was
No, which matter?
My lord, that DT Shri Jagat Janani Thakurani, Mr. Kaur was leading me and Mr. Dutt was on the other side.
Okay, okay. So that matter is ready for judgment. No, the question is, let it appear as to be mentioned. So question is, I granted that opportunity that if the matter is settled by between the
But
parties.
there is no scope for settlement. We have already tested. At least I do not find any.
So when was the hearing concluded?
My lord, hearing was concluded long back prior to the
Which date?
My lord, in the midst of September, my learned friend will correct me if I'm wrong. My lord, in the midst of
22nd, I think
22nd September.
sometime around 22nd September.
Yes, my lord. He is absolutely correct. 22nd September.
22nd September. Okay.
My lord, may I hand over the slip?
That is for?
My lord, it was CAV.
Yes. Now the question is, as because there was a submission on the part of the defendant that settlement talks are going on, I granted that opportunity that if the matter is settled, liberty to mention and it will appear as to be mentioned.
There is no scope for it is both Mr. Kaur and Mr. Dutt took pain to get the matter settled, but ultimately it was found that.
So after it is made, CAV steps were taken to settle.
My lord, no talk had actually taken
Your Lordship,
place.
that
It was made CAV.
there was a talk that took place earlier before it was made CAV when the meeting was held at Mr. Dutt's house. Lordship, Andrew and Jagajani, they were in the midst of settlement. It broke apart. Chances are for it to resume. However, as your Lordship pleases, your
Anyway,
Lordship
so
will keep it.
judgment will be
My
delivered.
lord, kindly tell me. May I hand over the slip if
Yes,
you want?
yes. That is with regard to this that case number.
Yes, number.
Yes.
Great.
Oblige, your Lordship.
Original site, daily list for judgment, item number 1.
আমি চলে যাবো সবাই।
Yes, I'm reading out the operative portion. Thus, the order dated 2/5/2025 should be recalled by allowing this application. Let there be an order in terms of prayer A and B of the notice of motion dated 14th May 2025. The suit which was dismissed for non-prosecution by order dated 2/5/2025 is restored to file. However, in order to expedite the matter in the interest of justice, this court is of the view that special officers should be appointed to resolve the disputes between the parties with regard to terms of settlement in accordance with law. Thus, so and so are appointed as special officers. Learned special officers shall, upon notice to all the plaintiffs and also their learned advocates, hold a meeting, and in the said meeting, if the dispute between the plaintiffs is resolved by discussion, learned special officers shall record the same, and the plaintiffs will be at liberty to take necessary steps in accordance with law for withdrawal or settlement of the suit. In the event the dispute cannot be settled by learned special officers, the learned special officers shall, upon discussion with the plaintiffs, fix a date and time of meeting to be held by the plaintiffs amongst themselves, in which the issue regarding withdrawal or settlement of the suit shall be discussed and steps be taken in accordance with law. The learned special officers shall also be entitled to appoint one of the partners who shall preside the said meeting of the plaintiffs. The presiding officer of the meeting to be appointed may be any partner, but other than plaintiff number 9 and 10. In the meeting to be held by the learned special officers, both the plaintiffs and their advocates may be present, but in the meeting to be held by the plaintiffs' partners with regard to the issue of withdrawal settlement of the suit, only the plaintiffs will be present. The meeting with plaintiffs shall be held by the learned special officers within 2 weeks from the date of the communication of this order. In the event any of the plaintiffs is unable to be present in the meeting before the special officer, he may send his learned advocate to represent him. But in the meeting to be held by the plaintiffs with regard to the issue of withdrawal of the suit, where any of the plaintiff is unable to make himself present, he has to give his views in writing to the presiding officer of the meeting in advance. In the said meeting, other than the plaintiffs, none shall be present. Upon the meeting being held, the plaintiff shall intimate the learned special officers forthwith in writing. The learned special officers shall, upon the meeting of the plaintiffs being concluded, file a report before this court on or before 5/1/2026. The report shall be filed before the regular bench having determination. As it appears that one of the plaintiffs is dead, steps shall be taken in accordance with law. Fixed 5/1/2026 for filing report. Yes. A11 of 2025 stands disposed.
Item number 2.
Actually, এটা কি আছে? Cost title-টা কি হওয়ার ছিল?
না আমরা জজই এনেছি, আমরা জানি না কেন
G1 of 2020. G1. Yes, this is put up for rectification.
No, Your Lordship, the record could not be traced out. There was a direction upon the department to trace out the record. Your Lordship.
Anyway, now the question is, after this rectification is made, the matter will go before the regular bench. Only for one rectification, the matter is listed. 24th October 2025. Instead of GA1 of 2024, to go out of the list, it should be GA1 of 2014. Do you have a copy of that order?
The second last line, my lord. It 214 হবে 24 এ যাবে।
So you see, on that particular day, GA1 of 2014 was in the list.
My lord.
So that application was directed to go out of the list. But instead of GA1 of 2014, it is marked as GA1 of 2024. That mistake has to be rectified. Thereafter, you take steps before the regular bench. Yes, record an order.
Lordship, I appear on behalf of the applicants in respect of IAGA 8, which is appearing before your Lordships today.
Which
IAGA 8 of 2025. That GA is also appearing before your Lordship.
Which case number?
Your Lordship, in this item number 2 itself.
Item 2. Anyway, whatever it is, the matter has to be heard by the regular bench.
Very well, Lordship.
Learned advocates for the parties are present. It is pointed out that in order dated 24th October 2025, it was directed that GA1 of 2024 to go out of the list. Let rectification be made. Instead of GA1 of 2024, let it be recorded as GA 1 of 2014. Stop. The matter may be placed before the regular bench.
Will it be your lordship's pleasure to take the affidavit of service and notice of motion in respect of
File
GA8?
it before the bench, okay? Regular bench. I'm not taking any matters.
Great.
Item number 3.
That I appear for the defendant numbers 1, 2, and 3.
Plaintiff respondent.
Clear.
Yes. Upon hearing the learned advocates and considering the judicial decisions, this court is of the view that as delay in filing written statement by defendant number 1, 2, and 3 is not willful, in the interest of justice, the defendant should be permitted to file written statement subject to the payment of costs. Thus, this application should be allowed. Let there be an order in terms of prayer A and B of the master summons dated 29th August 2024. This order is subject to the payment of costs of 300 GMs to the plaintiff within 7 days. As defendants are permitted to file written statement, order dated 25/1/2024 passed by His Lordship the Honorable Justice Krishna Rao, directing the suit CS 331 of 2013 to be treated as undefended suit with regard to defendant number 1, 2, and 3 automatically stands recalled.
Grateful.
Grateful.
Hello.
For hearing item number 4.
Rupa Ghosh was to address the lordship.
My lord, Mr. Ghosh is on legs before 25. My lord, if I can start, he will come and continue. Oh, yeah, one more.
My lord, today
Yes.
was fixed. I'm so sorry, my lord. I tender my apology for that day, but I could not make it to court. My lord, Mr. Ghosh on my left has made his submissions on behalf of the petitioner.
He has to reply after you conclude.
Yes. So he has made his submission on behalf of the petitioner
Yes,
who
yes,
has
yes.
made this application.
Yes.
On my right, Mr. Pradip Datto, senior advocate, has made his submissions supporting, my lord, Mr. Ghosh.
Yes, yes.
Now, my lord, as far as Mr. Datto's submissions are concerned, if I'm giving a joint reply to both so that Mr. Ghosh can deal with my submissions at one go. My lord, as far as Mr. Datto's contentions are concerned, he says, look here, I am not concerned with the dispute between the other two groups. I have 3 identified properties, which is lot C, and hence I want to get out of this mess, so to say. Please give me my properties. All the valuations are done. Give me my properties and I would be getting out of this joint mess. And I'll be enjoying my properties. Let whatever differences the other two groups have, group A and group B, lot A and lot B, let them sort it out between themselves. That is a long and short of his submission. To the other point that I had raised, that this is a suit for not for partition, but a suit for really, my lord, some declaration which have been sought for and an administration of estates. My lord, I had made a submission that no prayer in the form prayed for by Mr. Ghosh can be granted by this honorable court. Because if your lordship kindly looks at the plaint,
Your Lordship will see prayer
This is
IA.
for declaration and partition.
No, only, my lord, subject to correction. It is a suit for declaration and administration, not for partition. Kindly takes the plaint once.
What was the prayer made in the suit?
Yes, kindly takes the plaint once.
Yes.
Kindly call for the plaint and look at the plaint. Amended.
It is not annexed, no?
No, my lord, kindly calls for the plaint and takes a look at the amended plaint. But I have a copy. I can hand up a copy to your lordship. नहीं है आपका
Records to SC.
Plaint नहीं. Very well, my lord. May I hand up a copy of the amended plaint? Kindly look at the prayers made in the plaint. Leave under clause 12 of the latest patent, IA declaration that the said 84 Cornwallis Street, now called as Vidhan Sarani, Calcutta, and number 8 and 12 Chittaranjan Avenue, Calcutta, being to and from part of the estate of Kalipada Barik, deceased. So, my lord, essentially the prayer is for declaration that 3 properties form part of the estate of Kalipada Barik.
That declaration is done probably.
No, the
declaration of share is also not done.
Nothing is done. Nothing is done. Then kindly see.
There are 2 phases of a partition suit. One is declaration of the shares preliminary.
Absolutely preliminary degree,
and
then
final degree.
final degree after.
Here there is no preliminary degree. In the instant suit.
No preliminary degree because it is not a suit for partition. Kindly see. Then see 1B, possession of the said premises number 8 and 12 Chittaranjan Avenue. They are wanting possession. And my lord, declaration that these properties are a part of the estate of Kalipada Barik. Then see 1C, declaration that the said indenture of conveyance dated 16th November 1965, it void, illegal and of no effect. D, the said indenture of conveyance dated 16th November 19 be ordered to be delivered up and cancelled. Then 1E, an account to be taken and an inquiry be directed to ascertain the among the rent, issues and profits realized by the defendant number 8, 9, 10 and 11 from the said premises number 6 and 12 Chittaranjan Avenue, and decree for such sum as may be found and owing to the said estate upon such inquiry. Then prayer 2, administration of the estate of Kalipada Barik since decease, accounts of the defendant Shambhunath Barik of his dealing with the said estate, 4 accounts from the defendant number Sharajendranath Barik and Shachindranath Barik, decree for maintenance of the maintenance at the rate of rupees 2000 per month, orders for interim maintenance, 7 decree for areas of maintenance at the institution of the suit, suitable house for separate maintenance, declaration of charge of maintenance upon estate of the said testator, receiver, discovery, such further or other reliefs. So your lordship will be amazed to find that there is no prayer for partition, there is no prayer for declaration of the shares inter se the parties. This is not a partition suit. The suit for declaration that certain properties are a part of the estate of Kalipada Barik, cancellation of the conveyances executed by some of the parties in respect of some of the properties, accounts and administration. If that is the form of the suit as it stands now, this is the amended plaint as on date. Now kindly takes the first prayer of this application that my learned friend has made. How can it be said to be an application within the 4 corners of the plaint file?
This is GA23.
Kindly see the application that my learned friend Mr. Ghosh's client has made.
Yes.
Kindly see the master summons. To master summons to Devin Joseph. This is GA 23, IAGA number 23 of 2025. Kindly see the master summons, what has been prayed for. Prayer A.
Yes.
A preliminary decree be passed in terms of the admitted lots by the parties, more particularly described in paragraph 14 herein, and in the annexure A to the affidavit in support of master summons. B. A commission be appointed, be issued to an advocate with a direction upon him to partition the residential property at 194 Vivekananda Road as indicated in Lot A and Lot B as agreed by the parties, more particularly described in annexure A to the affidavit of master summons. And thereafter final terms of settlement to be filed in court for final decree in the suit. Such further other orders. Lord, I pose a question to myself. Where is the scope to pass these two orders within the framework of the amended plaint and the prayers made in the plaint, seeking for preliminary decree of partition and appointment of commissioner of partition and seeking for final decree of partition? Where is the scope?
So far, one of the defendant is concerned, that is Mr. Datto's client, that so far his share is concerned, that is adjusted in whole or in part.
Nothing. My lord, I say not at all. I will show.
That was
your
stand that your share is adjusted in part.
It is not.
So
It is
whether
not.
your share is admitted and adjusted, that was your stand.
Adjusted.
No, this is a factual aspect, what I am just clarifying.
I have preliminary. No, I have made this. I have made
No,
this.
I was clarifying from you whether one stand was taken that part of the share is adjusted and admitted. So far.
Nothing is admitted, my lord.
And nothing is?
No shares of the parties has been admitted in any document. What has been shown to your lordship, just to refresh your lordship's memory, what has been shown to your lordship is a minute. A minute or 2 minutes to be more precise, where, my lord, Lot A, Lot B, Lot C has been discussed. In 1 minute, Lot A, Lot B, Lot C has been discussed without giving the particulars as to what is Lot B, Lot A, what is Lot B, what is Lot C. And it is there, it is recorded there that parties may take this, but subject to other things being finalized. Lord, question is, yes, a suit can be compromised on any terms between the parties, provided every party gives consent. The same matter where I had argued before your lordship, Mr. Ghosh was also there. If the parties agree, all the plaintiffs and all the defendants, that yes, suit can be disposed of in terms of settlement signed by all parties, no difficulty. No difficulty.
Sometimes there may not be compromise, there may be adjustment or part of the claim has been met.
But that has to be agreed that this has been met by all parties. On record, has all the parties have to file a terms of settlement before your lordship, signed by them and their respective advocates.
And where the court finds that
Yes.
part of the claim is met or adjusted.
There is no adjustment in this case. It's nobody's case. Anybody has got any property. Nobody's case. Everybody is wanting properties to be conveyed in their favor. My lord, let me dispel this, my lord, thought that possibly lordship has formed this impression. Let me, my lord, with the deepest humility, my lord, try to dispel this notion. My lord, there are properties, say 10 properties that the parties hold jointly. Now, my lord, what has happened is Mr. Ghosh's client has come forward and made this application saying that, look here, the parties have sat in a meeting and have held and has agreed that they will that group A will take 3 properties, group B will take 3 properties, and group C will take 4 properties. So he has made this application inviting this court to pass, first of all, a preliminary decree of shares based on that meeting, number one. Number two, he has asked your lordship to appoint a commissioner of partition to divide the properties based on that meeting. Now, my lord, that could have been done if, my lord, all parties before your lordship now, including my client, said that yes, that is the position in law. These minutes are the final binding minutes between the parties, and they are agreeable to settle the suit or decree the suit on these terms. It was possible, but my client is not agreeing. I am not saying, I put it on affidavit that this is not the final terms. Those 2 minutes are not the final minutes. Those 2 minutes itself show that certain other things are to be done before the settlement is to be given effect to. I have clearly argued that Schedule A, Schedule B, Schedule C properties, the details are not given in that particular minutes. And my lord, hence there cannot be any meeting of minds, and my clients do not agree. Now, in that view of the matter, if Mr. Ghosh has to now succeed in this application, he has to first show before your lordship that these prayers made in his application are within the 4 corners of the plaint. I am saying, you have seen the prayers of the plaint, you have seen the prayers made in the application. They cannot be passed if all parties do not file a signed terms of settlement before you, because this is beyond the scope of the suit. It is not a partition suit. That's my first argument. Now, my lord, just to, my lord, avert to, my lord, Mr. Dotto's argument in this regard, Mr. Dotto has argued that although the suit is framed like this, even in an administration suit, partition can be granted. And my lord, if I am not wrong and my memory is not failing me, he had said that there are umpteen number of judgments in that regard. But my lord, he has not cited any. If he cites any decisions, I will be in a position to distinguish them. But no decision has been shown to your lordship that in an administration suit or a declaration suit, court on its own can mold the reliefs and pass a decree for partition. I am saying that power is not with the court, with the deepest of respect to the court. If, my lord, any judgments are shown to the contrary, I will be in a position to distinguish them. My lord, maybe come back on another day. I believe your lordships are rising at 2:30.
3:30. Actually, I did not get that information anyway. Anyway, thank you for reminding me.
We all got the information, my lord, from beforehand.
Why Friday you have some difficulty? This Friday, coming Friday.
No,
Wednesday is better, my lord.
Otherwise, you see, I take up this part of matters on Friday.
না না সে হয়ে গেছে, সেই উপায় নেই কিছু করার।
হয়ে গেছে, আরে বলছে বিয়ে হবে।
বিয়ে গতকাল হয়েছে, সবে আজকে বউ নিয়ে এসেছে বাড়ি। My learned junior is getting married, but that should not come in the way the matter is, my lord.
No, if you are engaged there, so you
No,
cannot
my
devote
lord, I'm
time
not
there.
His stomach may not permit.
No, I'll make myself
If you want
available.
your junior's appearance in the matter, I can adjourn it, no problem.
My lord,
Matter is
Friday
pending since long. Friday, your lordship keep it,
is
my lord.
not a very congenial day for arguments. Kindly keeps it on Wednesday. We are all.
Wednesday, your
The
lordship.
other matters are there. Actually, I take up part, try to take up part. This is a special case. Okay, considering your convenience, I kept it today. Actually, tomorrow, I have already kept one matter at 2 p.m.
If your lordship keeps it tomorrow.
Tomorrow, 2 p.m. I have kept a matter. Anyway, I don't know whether time will permit or not, because 3 p.m. there is another fixed matter.
Then, my lord, maybe we'll not.
Either then keeps it on Friday.
2 hours, complete 2 hours time. After the anyway after second half, my lord.
My lord, Wednesday, if it's possible, Wednesday week.
I don't know whether in appellate side I have fixed any matters or not. আছে কেউ appellate side এ দেখুন।
3টের সময় আছে, my lord.
Next Wednesday.
সামনের বুধবারে আছে কিছু ম্যাটার?
3rd December.
সামনের বুধবারে আছে ফিক্সড ম্যাটার আছে? সামনের বুধবার 3 তারিখ কোনো ফিক্সড ম্যাটার আছে? সিপিএম আছে, 2PM আছে। আর মঙ্গলবারে দেখুন 2 তারিখ।
আছে ফিক্স আছে ফিক্স আছে এই তো 2PM
আরে কপি রেখে দেবে
স্যার রেকর্ডে রেখে দিন
রেখে দিই প্রিন্টের কপি যেটা হ্যান্ড করবো সেটা ঠিক আছে ওটা প্রিন্টের কপি
যদি ফাইল এসছে ফাইলের মধ্যে রেখে দেখছি আমি হ্যাঁ দেখো তো আমি খোঁজ করছি আমি ফাইলটা এখানে পেলাম না পেলাম আচ্ছা ঠিক আছে এখানে ফাইলটা একটু দেখুন পেয়েছে দেখো আমি